Silence.
Minus में
Testing first. Yesterday, I have already considered a director. Where is the question? Yes.
minus
With
में
my lords. With my lords.
They're not registering my vehicle from the past 4 years for some technical reasons.
What is urgency now today?
We are just like that.
4 years have lapsed. Having waited for 4 years, what is urgency?
I needed it in next year.
No. What is the matter? No. No, no.
Revision matter. Therefore, permit has been released. My case complaint has been filed. It may be taken as
No.
for the hearing. Because the motion was earlier not.
No.
But the clause to direct and post it on listed. Not listed.
What is the matter?
Closing of described.
Closing of? What closing of the file? No. Item? It will be listed. What is urgency? Yes.
My lords may allow us to.
Petitioner has obtained the status quo order. That is listed on 70. The opponents have filed counter alliance. Second step petition and early listing petition.
It will be listed. If you file early listing petition, it will be listed. Yes.
Last Friday, my case was listed as contempt case.
No. No. Contempt is no offense. It will be listed too. It will be listed tomorrow. Yes. Yes. No.
Behind parts, my lord. They have filed complaint has to be taken up just for final hearing, my lord.
Why all these days? Why you waited?
They filed a petition recently, my lord.
You wait. You wait. You wait. It has to be heard finally.
Any date, my lord.
No. Yes. 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 Anybody?
I am on VC, my lord. I have moved two applications, my lord. Consultation, my lord. One is a vacational stay and the other is early hearing. The occasion is an order passed by my lord's predecessor, my lord, by which status quo has been granted, my lord, for the work which is being undertaken by the applicant for my lordship, my lord, which is a joint venture company undertaking a real estate project. Now, the order has been obtained to misrepresentation, and the status quo order has virtually brought the entire work to a standstill. So what we are praying is, my lord, for an early listing, if not an early listing, my lord, at least an assurance, because we filed a reply and the pleadings are complete, that the matter be actually heard on the 17th.
You already filed an application seeking early listing of expedited petition. That will be listed. We will
Yes,
consider.
sir, we filed that and vacation.
It is-
And vacation.
When it is listed, we will consider.
Right.
Yes.
My lord, all I'm praying is, my lord, it may be heard on the 17th, my lord, because this order is working to a disadvantage.
No. Yes.
Lordship, kind permission.
I am
May I
appearing in a
permit
matter,
to
my lords, in same matter where senior counsel represented my lords. Senior counsel is requesting for 17 my lords. May I pass on the slip, my lords, to my
No.
colleague?
No. Yes.
Lordship, kind permission. Am I permitted to make a mention, my lord? My lord, writ petition 29598 of 2023. It's a admission matter under Motor Vehicles Act. My lord, just before vacation, the lordship directed the matter to be posted after vacations. My lord, the matter is not even listed as, my lord, in the quarterly tax has to be paid for the
It will be
December
listed.
quarter, my lord.
It will be listed. There is no urgency. Yes.
Visual mentions. Number 1, item number 1298. Page number 3, item number 22 to 35.
42 may be taken after 1 month, my lord.
Item 23.
My lord.
Yes. 23.
42, my lord. Lorships.
Young counsel for the petitioner has appointed that no further acts are necessary. This petition is dismissed as instructions. Item 24. Why? When it reaches, you make a mention.
Lorships, my item 42 may be taken after 1 month, my lord.
Page number 4, item number 32.
Yes. Why? Who went for surgery? 46. Yes, as a request of learned counsel for the petitioner. Have you informed other side? Well, some Sudhakar Rao is there, but first you inform and come. Yes.
Lorships, my item 42, my lord, may be taken after 1 month, my lord. Rowdy sheet matter, my lord.
Why?
42 item, my lord. Rowdy sheet matter, my lord.
Item 42 is rowdy sheet matter.
Yes, my lord. After 1 month, my lord, please.
Yes. Is this case
Much obliged, my lord.
on 14 to it? Page number 5, item number 55 to 75. Item number 68. Yes. By tomorrow, today it will be taken up. Then, yes, you want, I will give a long date, or else argue the matter today. Yes, list this case on 7/12/2020. It is the request of learned counsel. Yesterday? Yes, you argue no matter now. What is the difficulty? I will give a long date if you want. Yes. Page number 6, item number 76 to 92. Page number 7, item number 93 to 105. Page number 8, item number 106 to 112. Item number 1, make a Muki. Red petition is allowed and the respondent for is directed to address a letter to the commissioner, who in turn shall address a letter to the immigration authorities as expeditiously as possible, preferably within a period of 4 weeks from today, to close the lookout circular issued against the petitioner. Item number 2, Claro, what is the vehicle involved? Because it's 1 lakh. $75,000. Item number 3, money partially. Yes. AGP seeks time to get instructions. Is this case on 23/11. Item number 4, Mr. Mallikarjun Shastri. Yes.
September onwards, without resisting, this Singapore is taking a red commitment to them. They have got the complaints, they have taken away my complaint, no problem, and produced before the state police of Thailand, and they have taken away 52,000 police pocket, not seen the case also. When a complaint to local police China,
Yes, what do you say?
The petitioner will take up of it.
8/9/2023, you have submitted a complaint. What is that evidence you are having to say that you have submitted a complaint?
really complained about.
Yes.
89, page number 18, Your Lordship.
What is that evidence to say that you have given a complaint?
You should acknowledge that I will not.
Where is that written? Acknowledgement.
Will file, Your Lordship.
Why you have not filed along with the red petition?
Now we have got to file a private indictment for the court. When that will be-
What is the difficulty for you to file an acknowledgement along with this complaint?
That's true, Your Lordship. Already we have sent. Received and acknowledged with our office. That's-
Yes, list this case on 7/12. Item number 5. Sanjay. Yes, yes. Police protection? Why you are asking for the police protection? Yes. Yes. Yes.
In action of respondent number 2 not passing and not disposing of revision. Again, CMI number 2017 dated.
Why officials are coming? Why officials are coming regularly?
Official respondents and official respondents are trying to this process is from my hand.
Official respondents are.
Official respondents are handling your official respondents.
Why you have not made them as a party respondents? Yes. Therefore, you have to make them. Somebody is, according to you, somebody is interfering with your question. Who are they? Who are they? Who are interfering with your question? In this repetition, I am asking who are they interfering with your question? In this repetition, I am asking who are interfering with your question? What is that representation when you have submitted representation? Where is? Yes. Stating what? If somebody is interfering with your question, go before civil court, institute a suit and obtain an injunction. Who are dispossessing? If they are dispossessing, if they are dispossessing you, go and file an appropriate application in the very same writ petition. In the very same writ petition, you file an application. Why you file? Why you? Therefore, you filed appropriate application in pending CMA. Why you want to? Yes, read that order. Yes.
Still pending for respondent number 2. That is additional agent to the government. This court deems it figure forward to direct respondent number 2 to consider and pass the complaint order. On the revision petition, filed the petition of case 1. So again, the order of CMI 2017 dated 13/12/2019.
What happened?
It is still pending in objects and they are not.
Therefore, what is the remedy? Therefore, what is the remedy if they have not complied the orders of this court in passed in WP number 222596? What is the remedy available to you? What is the remedy available if they have not complied the orders? What is the remedy available if they have not disposed of your revision petition as per the directions of this court? Have you filed contempt case? You file a contempt. You file a contempt case. Why you are asking any relief in this petition? Get instructions. Yes. List this case on 712. Notice already taken by the government pleader. You have not made them any other parties as a party respondents. Yes. Yes. What do you say? What revenue authorities? They have submitted a complaint dated 4/9/2023. Competent. What are the allegations? What are the allegations in your complaint?
Which is why I made a complaint to the Commissioner of Police also. No response.
Yes. It is tampering of the records, revenue records. What is the remedy for revision? Remedy for correction of the records is a different issue. But when there is an allegation of tampering of record, you are entitled, and even sanction of the government is not necessary for the Tahsildar when there is an allegation of tampering of records. You stating what? Have you submitted any complaint to the collector?
I have submitted, I have not filed that, filed it here, your lordships. But there is a tampering of record, your lordships, by the revenue officer. And there should be some criminal action against it.
Since now they have closed your complaint, the remedy, they will serve a copy of the closure report. You take steps under section 202 CRPC.
Nothing, they are not.
If you made collector as a party respondent, I would have been granted a direction to the collector to act upon your petition.
You and the petition, or your lordships may allow me, if your lordships is granting me that opportunity, your lordships may allow me to impede the collector.
Your main relief is something else, I was. Therefore, you have to file a separate petition.
There is a serious issue, your lordship.
Therefore, so far as you are having a two remedies, one is prosecution of the Tahsildar or other revenue authorities under the criminal procedure code, either filing of the private complaint under 156(3) for reference of the complaint, or filing a protest petition, because though there is no sanction is necessary when a personal malafides have been made against a particular officer, and it is not amounts to discharging the duties officer to take a protection. Therefore, sanction of the government is also not necessary.
Yes.
Therefore, you are entitled to file those two petitions before the competent criminal court. Besides that, you are also entitled to file a representation to the collector. If such is the case, we will direct the collector also to examine the representation.
I am surprised, your lordship, that without even telling me they have closed.
So why you have to furnish a copy of the closure report?
They have not, otherwise I would.
5(9). So how you have informed on what is the mode of information you have furnished to the petitioner? Send a SMS to the petitioner. Why have not sent a copy of the closure report to enable the petitioner to take appropriate steps? Because this writ petition has been filed on 7/11. If you have communicated to the petitioner about the closure of his complaint dated so and so 5/9, you would not have been taken steps of filing of this writ petition. What is that evidence you are having to say that you have communicated that message on 5/9? Don't play with the courts, creating some evidence. Yes.
Let them file a counter register.
Not as unnecessarily, it will be delayed further time.
But your lordship, it is.
You are having three remedies. You are having three remedies. You file immediately a writ petition for saying that I will also give a liberty to you pursue the remedies. The petitioners are claiming. Page?
Page 13 of my legal papers.
Yes.
last para కావున తమరు మా యందు దయతలిచి మా యొక్క వ్యవసాయ భూములు రికార్డులను ట్యాంపరింగ్ చేసిన మానకొండ తహసీల్దార్ గతంలో చేసిన ఎన్ లక్ష్మారెడ్డి గారు మరియు అధికారులు మరియు దాసరి స్టూడెంట్స్ మిగతా వాళ్ళపై విచారణ జరిపించి మాకు తగు న్యాయం చేయగలరు.
The complaint is with regard to tampering of the records. It is not with regard to somebody is obstructing with the possession. If somebody is obstructing with the possession of the petitioner, she would have been taken steps of filing an appropriate suit and obtained an injunction. Thereafter, she would have been come to you for registration of the crime. It is a case where she is making a specific allegation of tampering of the record. The complaint discloses a cognizable offense, and your report, closure of report is something agricultural land from the abused the complainant in a filthy language. Where is that? Let him file count.
Very well.
Yes, sir. The request of
Item number 12 and 13 are also the same.
yes, the request of the learned counsel for the government, Eastern Government. Is this case for filing of counter affidavit on 30/11/2020? Positively, you have to file on 30/11. Yes.
Item number 12 and 13 are also similar.
Item number 12 and 13 also goes together. Post all these three writ petitions. You file a consolidated counter affidavit at least in one case. Yes.
Item number 7, Mr. Srinivas Reddy.
Yes.
Appearing online.
Yes.
My lord,
Yes.
this is the case of the cheating against the petitioners, my lord. The petitioners enter into an agreement and pay the advance amount of 5 lakhs for an apartment, my lord. But they obtained for they approached the bank authorities, but the bank authorities rejected the bank loan on the ground that instead of constructing the G+2, the unofficial restaurant constructed G+4, my lord. And there is a horizontal deviation of 28%, my lord. Hence, they rejected the bank loan, my lord. And the petitioners approached the unofficial respondents and asked their advance amount to return back the amount, my lord. They rejected, my lord. They cheated, intentionally, deliberately cheated the petitioners, my lord. Kindly register a claim, my lord.
Without verification of the whether the complainants are, whether the respondents are having a permission from the competent authority or not, what prevented you to enter into an agreement with them and payment of the
There is an agreement, my lord. Kindly, there is an agreement, my lord.
an agreement? Why you entered an agreement without even verification of the documents properly, that whether the constructions are legal or illegal?
The agreements given by the petitioners are genuine, my lord. But he cheated, my lord.
Go before civil court and
My humble submission, my lord. Kindly pass the order to register the case, my lord. My humble submission, my lord. I beg you, my lord.
I am dismissing your writ petition. Go.
I beg you, my lord.
Yes, Randy. This writ petition is filed seeking following the question. The petitioner case is that the sixth respondent offered to sell the flat number G2 in ground floor with the built-up area of 1170 square feet.
My
which
lord,
is
kindly
of
on merciful grounds.
inclusive of common areas and one car parking. The building known as Ankur Homes, together with undivided share of land at measuring 22 square yards, constructed at block number 56A and 56B in phase 1, survey number 181, part situated at Sri Raghavendrapur housing colony, Upalagoda village. It is further case of the petitioner that the case of the petitioner, it is further case of the petitioner, he agreed to purchase this flat and paid in advance the total sale consideration of rupees 55 lakhs and entered an agreement of sale with the respondents 6 to 7 and paid an amount of rupees 5 lakhs as advance sale consideration on 23/1/2023. The grievance of the petitioner is then he approached with agreement of sale with the banks for financial approached the bank for loan, housing loan. The same was refused on the ground that the petitioner has constructed this apartment in violation of the building rules and contrary to the sanction plan. Then the petitioner has demanded the respondent to return the advance sale consideration amount. The same was refused to pay on the ground that there are similar refusal to pay. Stating the above said fact, petitioner stated to have been submitted a complaint on 13/8/2023 to take appropriate action against the respondent 6 and 7 for registering the case. On careful examination of the content of the affidavit filed in support of the petition will disclose
that there are serious civil disputes between the petitioner and respondent 6 to 7. And that admittedly the petitioner has entered an agreement of sale to purchase the flat on 23/1/2023. It is everybody's knowledge that the agreement of sale would be entered only after verification of the documents, including the sanction plan. Therefore, if there is any deviations with regard to construction, petitioner is entitled to approach. If any deviations in the sanction plan, the petitioner is entitled to either make a representation to the municipal corporation, remove of deviations, or to institute a appropriate suit before the competent civil court. If this complaint file prima facie appears to be not maintainable, and there are serious civil disputes. In view of the same, the petitioner is given a liberty to approach the competent civil court for recovery of his amount paid in pursuance of the agreement of sale. Above observation, this petition is closed as no orders are necessary. Yes. Yes. Post. Right. What is your case? Yes. What do you say? Yes. Land master government paid 6 times to get restrictions. This case on 30/11/20.
Number 9, Mr. Mohammed Daud.
Who is interfering with I-handed? Who is the third respondent? Here is the permission obtained by you. Show me the permission copy. Page number? Yes. Yes. When you obtained building permission, then there is the question of now they are interfering with your construction activity. I don't know. Show me if subsequently fourth respondent demolished your building. Have you obtained? Show me the permission obtained from the municipality. Page number? Yes. Page, show me the what is there in page number 52. Yes, this is registered on 11/7/2023. What is that you want now? Where is the permission for renovation of the building? Existing building also for renovation, you require permission under the municipal corporation. Show me the permission granted for renovation of your building. What is that Gram Panchayat? Mirpet is now municipality. It is not a Gram Panchayat. Show me the permission obtained from the Mirpet municipality. Page number? Therefore, where is the question of now you are constructing? Fourth respondent? Your renovation, show me the building permission. Here is the complaint if recently demolished. Yes. Yes, they will conduct an inquiry with regard to the FIR. Now, where is the permission? Show me that you proceed with the construction activity. Yes, petitioner is permitted to take out personal notice to the fourth respondent, file proof of service by the next date of hearing. This case on 14/12.
Spread of the industry like never. The option is called leading spread of mesh. Start with the key by something.
the police is not insisting the case, and given a complaint on
Read your complaint, whether it is,
31123.
yes, read your complaint.
Page 10, your
Yes.
complaint against the refractory is the in spite of the brilliance of
Read your complaint.
the submitted and the parent of only I'm running value business in the property of the nations. So the same member, he died in the month of that one casting. That one of the words of my living to that age and the last time to disposing of the property about that we do not suffer. I submitted not to save my business property. I filed to transaction not to court and on basis of document evidence filed by me on 8 Venus Major, granted major for us to make favor. And I report 8 persons. I remember source.
What is that complaint? Is there any, this complaint discloses any cognizable offense to register the case?
Yeah, on page 11. Paragraph 3 also.
Yes, I have read. I have read. If there is a violation of injunction, you file a contempt against them.
My defense is that is threatening me to kill without standing in front of
Where you have stated they are threatening to kill you. A complaint.
in the people.
You can't mention in the WP. It should be contained in the complaint. You are not supposed to say so many things in the affidavit which are not there in the complaint. I will dismiss the writ petition. Yes, right. No. Once I heard the matter, there is no question of case. You avail the remedies as available for enforcement of the injunction case by filing contempt case. If somebody is violated, you file case. The petition, writ petition is filed seeking following the link. The petitioner claims to have been instituted OS number 3790 of 2023 in the file of the
Questioning the action of the third responsible party. Second, the so following the procedure.
yes. Right. The case.
Trying this repetition, yesterday they came into petitioner brother-in-law, they served notice. But they have taken up. And
The petitioner claims to be.
they are not willing to follow procedure.
I will
Properly investigating the crime number 495 of the property.
What do you mean proper investigation means?
Crime number registered month of June, still there is a no charge sheet and no investigation has been started.
Yes, what do you say? You furnish the whatever information it is required by the police file.
It's already set. A page with all the documents and everything.
Page.
Page number 21.
Yes.
The detail.
1 minute. Yes.
Page 21. Detail completely. With all the.
Yes, where is the notice? When you have issued the notice? Twenty-three? 27/6/2023. Stating what? When you have issued the notice to the sub-registrar and district? 19? We are in what month now? We are in now in almost November. Why it has taken such a long time for securing the documents from the office of the sub-registrar? You simply throw away a letter to on the face of the sub-registrar and keeping silence over the investigation. I will direct them to complete the investigation within a.
Respondents are now responding on the dead person.
They will now they have registered a case, they will complete the investigation and file a charge sheet case. Right? The petitioner is the de facto complainant. The petitioner. Yes. Yes.
Then Malad, they file an appeal was dismissed.
Yes.
Then the file is second. The idea was dismissed, Malad saying that you have no rights
order of protection. Then there are a petition for police protection. When this court was used to grant it a police aid. In spite of that, now the police is helping the unofficial respondent and evicting me, and they are allowing to be make a construction over the property instead of giving a police aid to me. Kindly may please to be look at that page number. Page number 82.
Page number?
82.
Yes.
They shall be issued direction to the court to respond to provide message to the petitioner against the response by the anyone for implementing the person in order 100 judgments for indirect respect of petitioner's property. Second appeals petition, they file a second appeal.
Now injunction is subsisting as on the.
Yes, sir. Degree also.
So what is your grievance?
Now, madam, they are allowing to the unofficial respondent to make a construction of my property.
See, if how can you proceed with the construction after obtaining permission only will proceed.
Where the police is, madam.
No, if they after obtaining the permission from the competent authority only will proceed with the construction. Have you questioned the construction permission being granted to the another?
No construction was granted.
Construction permission,
I am not making any construction.
not you.
The other side.
The other side, when he wants to proceed with the permission, proceed with the construction, there must be some permission being obtained from the competent.
No permission is
Here you have stated in your affidavit that no permission being obtained by. Yes.
Before that, madam, I want to show the one second appeal start.
Yes.
Page number 84 and one.
Yes.
Page number 84.
Yes.
He filed a second appeal. But order is that appeal is filed suspended. He has seen the record. There is no document conveying over the suicide property in favor of the petitioner where the respondent already have a document. Several other documents to show position of suicide. Under this circumstance, there is no problem.
When you are in possession of the property, there is. When you are in possession of the property, where is the question of somebody is constructing
The
your.
police is now helping them with that. You I stated
Yes.
Page number 15,
Yes.
respondent submitted a respondent to receive the complaint after the petitioner refused to do any acknowledgement and compel the petitioner to sit up to 5 o'clock and send the sub-inspector to police.
If respondent number 4 refuses to receive the complaint, have you brought the same to the notice of higher ups?
Yesterday,
Have you brought the issue to the higher notice of the higher authorities?
people are moving around.
Ordinary people, when they approach this Mukhi, the advocate, they are equally capable of approaching the police also.
Sub-inspector of police Prem Kumar to protect the unofficial respondent, their henchman and warn the petitioner not to visit the property. So, my lord, this is a handless, my lord, as the pursue the.
It is your allegation why you have not brought to the notice of the higher ups.
That is although he went to a city was not responded.
So what is the direction you are asking now?
Now, my lord, to implement the orders of this court, court was passed an order to be given police aid as because of protect the degree.
See, police aid has not been given as per the directions of this court. You are having a remedy of filing of contempt case. You are having a remedy.
Instead of me.
You are having a remedy of filing of contempt, saying that even after direction. You file a contempt.
Yes,
Not you are not supposed to maintain second petition on the same set of allegations.
but my way is not for that matter. He is helping the unofficial respondent.
I can't decide in a writ petition somebody is helping.
Let me ascertain that matter of fact. Both sides stated so. They are just.
Yes, what do you think?
Me and so pursuing the litigation.
Already there is an order of this court to directing you to provide the police aid. Have you provided the police aid? Why you have not granted police aid to the petitioner even after the directions issued by this court in WB number? Randy, the case of the petitioner is that he is an absolute owner and possessor of the land. Where the land is located? What Pandit? Let him appear and explain what is the difficulty for you. Yes, list this case on 30/11/2023.
Mr. Hemant, sir.
Who is Arashi? Page number? Yes, what do you say? Have you followed the procedure? Now they will serve because it is their case that they are following the procedure. Yes, Rani. The grievance of the petition. The case of the petition is that the fourth respondent. What is the role of the fifth respondent? Yes, what do you say? What is the offences alleged against the petitioner? Section 420 IPC. Yes. You complete the investigation and file the charge sheet expeditiously. I will grant 2 months time. Yes. In view of the elections, I will grant 3 months time. Yes. The grievance of the petitioner. You are the de facto complainant. What is your name? Perumala Sukanya alias Allamala Sukanya. You are the petitioner here. Yes. The petitioner. Petitioner is the de facto complainant in a case in crime number
Yes.
Please, your lordship. Lord, the petitioner before lordship is aggrieved by the inaction of the respondents 3 and 4 in not registering FIR and taking up investigation in spite of the directions given by the Honorable 17th Additional Chief Metropolitan Magistrate Millard on 15/9/2023, which was also referred to the police and received by the police. Millard, still they are not taking any.
When the said complaint has been received, when the said complaint has been received,
Yes, Millard.
when the complaint has been received by the police, the complaint referred.
Millard, I may permit to take your lordship material papers. Millard, page number 30 of the material papers, and I have filed the typed copy also. Millard. That is on page 30, 37, Millard. 37.
37.
Yes, Millard. And the police, they gave very, peculiarly that the complaint has been disposed of and closed. Thereafter, again, Millard, the respondents, Millard 6 to 8, again they attacked me. Millard, they came to my clinic with the hooligans, they attacked me and they threatened me with the direct consequences. They said they are going to close down the Jubilee Hills unit also, where I have given the Millard establishment on lease basis.
9/8/2023.
In pursuance thereof, Millard, I lodged a private complaint. Private complaint was received and referred to the police. Millard, I may permitted, I request your lordship, Millard, I filed the copies of the private complaint also, and also the.
When this complaint has been referred by the the concerned court to the police for registration of the crime.
Yes, Millard, that is on page 24. Millard, the private complaint is from page 18 onwards. Page 24, 25, Millard. 25 is the docket order, Millard. Page 25, Millard.
Even before your complaint being referred by the concerned magistrate, they have already given an acknowledgement dated 9/8/2023. What are the offences?
Yes, Millard. Millard, offences, Millard.
Complaint seeks time to get instructions. This case on 30/11/2023.
I am deeply obliged. Deeply obliged.
Yes. Page number 52. Yes, what is the representation?
Was issued by the not responding to SI of police station, Agar 680 That's it. Now, very representation before this honorable court. And you have this honorable court order.
So when you have lodged this complaint and your repetition is not maintainable now.
After lodging this complaint, the repetition before this honorable court. Page number 49 and 51.
Yes. Yes.
51 permission is sought to this record. Then council appears to the seeks permission of this group to withdraw the petition. Human rights commission. Thereafter, I approach the human rights commission. The human rights commission order is at 43, 44.
43?
44.
Yes.
44 was petitioner is absent to represent the complaint and the summary substance of complaint of the petitioner is that on 25/8/2020 he gave a representation to the second respondent, who is the Director General of Police for the state of Telangana against the first respondent, who is the station officer T.S. Nagar.
Yes.
These documents are the sent to DGP for taking action. Since then, no action has been taken so far. But how to effective order to remedy these council check this out. The way to directly eligible to dispose my representation card is.
See, what is the complaint? What is the basis of the complaint?
Basis of the complaint is my embezzlement, my complaint. And also the photographer.
Yes.
My 58.
But the Human Rights Commission has directed the Director General of Police to examine the complaint submitted by the petitioner. So the Director General of Police, State of Telangana, Hyderabad, for early disposal of the complaint dated 25/8/2029 for taking action on the merits under the intimation to the petitioner and this commission. What happened?
Page number 60, we have put your 60. That grievous injury on the right hand or it was attracted the attention of the newspapers. Page number 60.
Page number
60.
60.
60.
Yes.
The photograph of the petitioner showing the grievous injury in the right hand. Petitioner's right hand.
What prevented you to approach the by filing a private complaint rather than the approaching Human Rights Commission and Director General of Police? When you are having a remedy to file a private complaint under section 156(3) for seeking representation. Petitioner is able to approach this court by engaging a lawyer and filing a writ petition seeking withdrawal of the same with a liberty to approach the Human Rights Commission, and you are entitled to approach the Human Rights Commission. There you sought for a direction to Director General of Police to dispose of the complaint. When the petitioner is capable of approaching all these institutions in hierarchy system, what prevented you to approach the competent court for filing a private complaint? Petitioner is expecting? When your complaint does not disclose a cognizable offence, there is a question of registration of the crime. See, your writ petition is liable to be dismissed on the sole ground of delay and laches. According to you, you have lodged a complaint in the year 20. Now you file a writ petition. What is that relief? Therefore, you are waited for 4 years. You wait for another 4 years for disposal of your representation by the respondents. Having waited for the 4 years for disposal of your representation by the competent authorities, when you constrain to file the writ petition now, you wait for another 4 years. If the authorities have not acted upon immediately for disposal of your representation, you would have been immediately approached this court. Why you waited for the 4 years? And you are approaching various forums, Human Rights Commission, Lokaayukta, this court, withdrawal, everything, Director General of Police, Superintendent of Police. When you are having a right to file a private complaint also, when the serious complaint, when your complaint discloses a cognizable offence, straight away your complaint might have forwarded to the police for registration of the offences. Even they are not in a position to alter the sections what you have mentioned in your complaint. As it is, they will register the complaint. Whatever sections you mentioned in the
maybe possibility of legal approach by the concerned council.
When a concerned council is allowing you to approach this court, what is the real? This is other way around of suffering the client, unnecessary advices by the client, by the advocate. And it is not the case of somebody has not acting upon the complaint. It is a case of misguiding and by the counsel to the litigant public. And the persons who file the representations are liable for prosecution and the disciplinary action. Because having put a sufficient experience, you are not properly advising, you are cheating your client. When you are aware very certainly about the remedies available, why you are unnecessarily properly not guiding the party, an innocent, a rural man? Why you are subjecting repeated cases before this court and before Human Rights Commission? Yes, what is that action you have taken on the complaint being on the recommendation of Human Rights Commission? This is dated 21. What is the date of this order of Human Rights Commission? 27th August 2021. This is also delay. This is also delay. Even the for seeking implementation of the Human Rights Commission order also dated 27th August 2021, you filed this petition. This is after 2 years delay. You are aware that there is a delay in latches, there is a provision under the law The writ court can refuse even if you make out a good case for granting a relief. Even if you satisfy this court that you are having a case on merits, on the ground of delay and laches, writ petition is not maintainable, it can be liable for dismissal. Therefore, let the advocate may pay the cost. You said that because of the fault of the advocate, party cannot be suffered. Yes, you are right. The advocate who is responsible, let him pay the cost. Yes, what is? Why you have not acted upon the complaint being the complaint of the Human Rights Commission? No. When a Director General being made as a party respondent, is deemed that every person, every department, every officer is deemed to made as a party respondent. It is not necessary he has to made assistant sub-inspector, circle inspector, assistant commissioner, deputy commissioner, regional commissioner, additional commissioner, additional DGP, additional IG. All these are party respondents to the writ petition. When a Director General has been made, deemed that every person needs to have been made as a party because you are repenting state. State also made as a respondent. And it is primary duty of the state under Article 21 and 22 of the Constitution. Get instructions. What is that action you have taken on the directions issued by the Human Rights Commission dated 27th August 2023 by the next date of hearing. Then the Assistant seeks time to get instruction. List this case on 30/11/2023. Year after you file such a delay cases, I will impose heavy cost. And this is a practice of your office. I know about all these cases, Mr. Don't underestimate this court. The court knows about every character of every advocate also. You are aware or not? Yes. After elections, yes. List this case on 7/12/2020. Yes. Said vehicle was seized as in pursuance of the as a crime property. Then what is that vehicle involved? Huh? Yes, what do you say? Yes, at the request of the land government, is this case on 23/11. Number 21, Santosh Kumar.
Permissions from the consent authority. Now they are obstructing and demanding money from the patient.
If somebody is obstructing your position, what is the remedies available in civil law?
We have approached the respondent within 2 months and made a representation to me where we directed them to not to interfere in the position.
Who is this second respondent? So then even after the directions of the police, when they are interfering, what is that relief? What is the relief available to you under civil law? You have to go before a consent court, institute a suit, obtain an injunction, and if there is a violation of injunction, file a petition under Art 39 Rule 2A. And even after that, they are interfering, file a petition under Section 92, read with Section 151 CPC seeking police protection. When they have not granted any police protection, come before this court. Can this court is having such a power under exercising under Article 226 of Constitution of India to directing such a nature of relief, directing the parties not to interfere? Interference is a question of fact and question. Interference.
Not the private person, my God.
Respondent number 2 is?
Respondent number 3 to 5 who are police officers, my God.
Why they are? Petitioner and petitioner husband involved in a crime or for investigation purpose, you summoned the petitioners.
The other people are activities in my venture, my lord.
What
It's
is it?
nothing.
Yes, what is it? ఇక అందరు అయిపోయారు మీ పోలీసులు ఒక్కరు మిగిలిరు ఇక మామూలు రియల్ ఎస్టేట్ రౌడీ షీటర్లు వాళ్ళు వీళ్ళు అయిపోయినారు యూ స్టార్టెడ్ and it seems that your department is created only this purpose, not for the securing the rights of the citizens. I will dispose the writ petition directly. You are appearing for?
I want to file a petition disclosure. I gave it completely. On that instruction, where the police people
So what is your complaint discloses?
the petitioner's property is behind my property.
That is a civil dispute. It has.
Exactly. They are interfering through my property. I have laid boundaries to my property. They destroyed that. After that, I have given a complaint. Now they are come to this court saying, no, the police people are interfering. That's not the case.
If the offence has been registered against the petitioners, I will direct the police to follow the procedure contemplated under section 41 CRPC and also if you take appropriate in complete the investigation, file a charge sheet. It's ready. Madam, you have encroached the property of somebody else.
Even though
And you very intelligently converted the civil litigation into criminal litigation.
the petitioner is not denying their permission.
No, your implement is not necessary. I am disposing the petition. Petitioners. Petitioner claims to be owner of patadar and possessor of agriculture land to an extent of
Yes. Item number 22.
So anything survives in the writ petition? Yes, who is appeal? Yes, what is madam? So there was an interim direction by the division bench of this court, and you filed a counter affidavit also in this case. Yes. Yes, nothing else is there in this case. The contention of you is that your vehicles which have been used for the as a construction equipment vehicles, as defined under section rule 2 CA of motor vehicle rules, that is the vehicle of forklifts, will not fall within the definition of the vehicle. Therefore, the vehicles are not liable to pay the tax. Is your contention? Life tax is your contention. Subsequently, this court has taken a decision in WP number 173 of 2010 and batch, saying that the said vehicles are motor vehicles as defined under the Motor Vehicles Act and liable for payment of tax in accordance with law. I will dispose the writ petition. Yes, it is a conditional order. It is a conditional order. You have deposited 50% of amount, claiming that said vehicle is not a vehicle, it fall within the definition of Motor Vehicles Act. Now, in view of the judgments being, the decision being taken by this court in WP number 173 of 2010, nothing remains in this case. Madam, why unnecessarily it has to be adjourned? It is a 2011 matter. I will direct the respondents to take appropriate action strictly in accordance with the Motor Vehicles Act. Madam, you have also directed within a period of 4 weeks from today and on furnishing and undertaking not to remove the vehicles from the jurisdiction of the licensing authority and also not to alienate the vehicles. The vehicle seems to have pertaining to the year of 2011. Now we are in the 2023. Almost all vehicles are 12 years old. Even if you have given free of cost those vehicles, nobody else is ready to take your vehicles. ఇది ఐరావతం ఇప్పుడు ఆ వెహికల్ మెయింటైన్ చేయాలంటే యువర్ వెహికల్ ఈస్ ఓల్డ్ as almost 12 years old. Nobody will come forward to take 12 years old vehicle which has been used as a construction material equipment. What wakalat? Having received the instructions from your party, you would have been made an inquiry with the party saying that any cause survives in the writ petition. You are saying that you have to receive something material instructions in a pending case. That is an opportunity to the junior when a senior being designated as senior counsel. You file wakalat, get something and report to the court, nothing remains in this writ petition. It is helpful to the court as well as you yourself. Yes. List this case on Monday, not tomorrow. Yes. List this writ petition on Tuesday for orders. Yes, Mr. Raghunath, what is the matter? Anything survives? Anything survives?
Yes, madam. Not the case of student torture. Third-degree torture.
What is that evidence you have placed before this court? Is the accused has reported to the concerned magistrate about the custodial torture at any point of time? The accused has reported to the concerned magistrate about the custodial torture at any point of time.
Yes, he reports it very quickly. Unfortunately, the state was not inclined to report it. This is what is happening, but I placed before your lordship the report where this Honorable High Court has allocated the increased directions to the Nizam Institute of Medical Sciences when the victim was in the jail, Karimnagar district jail.
Yes.
The report shows that nearly about
Yes.
Nizam Institute of Medical Sciences dated 23/12/2020. 23/12/2020.
Yes.
The Honorable Chief Justice, it was addressed, and I take to the relevant area where the injuries, very brutal injuries, may not, it starts from number 1, page 2. It is about the base, temporary abrasions, abrasions in the gap.
Now, ultimately, what is that you are entitled?
Yes. Next page.
What is that your prayer is? Petition?
The prayer is that the Lord challenging the action of the respondent police, particularly inspector of police and sub-inspector, who have illegally detained me on 19.
Whether they are in service as on the.
This is my lord, it is a illegal custodial torture is a blow on.
I am only asking whether as on the date, whether they are in service, but alleged officers. The reason why I am asking you should be in a position. If they are not in the service, the state is liable, subject to court comes to a conclusion. If they are in service, I will direct the government to direct the whatever compensation amount, if it is going to be examined by this court, to pay from their salaries rather than paying from the public exchequer. You are aware there is a judgment of Justice Jeevan Reddy so far as the Mujirabad case is concerned, reserved long back in the year 1984, that in a custodial torture or an illegal detention, the person, the officer is liable, even though vicarious liability is cast upon the state. If he is in duty as on the date, I will, if the finding being given, the particular officers are responsible, let them pay. Why we should pay? It is not the state amount, it is everybody's amount, that if the state is paying that amount.
But one aspect, my lord, these officers indulge in such a brutal torture and the protection of the state executive.
No, state is liable to pay the.
State, we cannot ignore the state.
No, Mr. Raghu, I am not saying that the state is not liable. State is vicariously liable for the responsibility of officers. When an officers are in duty, first we should try to recover that amount from the officers rather than the imposing anything. We will direct the state to initiate disciplinary action so far as the findings are concerned.
Yes.
But any counterfeit has been. Have you made them as a by party by name? Have you made them as a by party as name?
Your lordship knows the police counter.
Who is appearing for 1 minute? You forget about Commissioner. Who is appearing for the 6th and 7th respondents? Sixth and 7th respondents are made as a party by name personally. Who is appearing? As the notices have been served.
The man was shifted immediately from because he went to meet her.
On what ground he has been arrested?
It was in the period of 2013 around where the Telangana movement is actually reached. The respondent number 9, who is the cabinet minister. And this gentleman, what he has done in the scene is, he has brought one pamphlet saying that who are anti-Telangana and who are trying to suppress the Telangana movement. That has made a glitch for him. He was picked up from the University from Hyderabad on 9/12/2020, straight away taken to Ramagunda police station, and there the students were brutally tortured. Like anything accident.
Is there any search warrant?
No search warrant.
How many days he was there in the custody of the police?
Yes, he was in the police custody, and
according to you, when he was arrested?
Just immediately by
What do you say about the report being furnished by the Nizam Institute of Medical Sciences? Dated 23/12. Dated 23/12/20. The committee constituted by the Nizam Institute prima facie of the opinion that there was an injuries being found on the body of the petitioner. Since there is a specific allegation that so and so persons, the respondent 6 and 7 are responsible for the injuries, illegal custody or custodial torture. And any counter affidavit has been filed by them. In the absence of they are filing counter affidavit to defend themselves as a respondents in the repetition. What is your role? Your role is only vicarious responsibility. That's all. When they are not denying, it amounts to admitting the contentions being raised by the petitioners. Is there any counter affidavit being filed by the?
They did not choose to file, but the state is trying to defend them.
The state is always the state because state trying to defend them in a good faith that they being the police.
This doesn't fall in the discharge of their duties with great respect.
That is the contention of the state, I am saying.
Very unfortunate thing.
Yes, who is appearing? Notices have been served on them or not?
Yes, my lord, sir. As a commissioner under whose duties.
No. For the respondents. Normally, police are under the impression. Mr. Raghunath. Mr. Raghu, normally the police are under the impression that even though they made as a party respondents by name, the government pleader for whom would represent them, they are under that such an impression, and the impression being created by our own people. But once they have made as a party respondents in a writ proceedings, in a constitutional proceedings, the Supreme Court said in Sayyid Yaqub. Yes, you are appearing for? Your role is very limited to the extent of report is concerned. Who is appearing for those two people?
For Sridhar Babu.
For Sridhar Babu, Niranjan Reddy is appearing. Yes. So far as your role is concerned, very limited. No. So far as the conspiration is concerned, the police would act upon for registration of the crime, and it has to be established after registration of the case. So far as the payment of the compensation is concerned,
not only payment of compensation.
What is that you are asking? What is that you are asking against the Sridhar Babu? What is the relief you are asking against Sridhar Babu?
It is an abatement under the criminal.
Therefore, a crime has to be. Therefore, according to you, a crime has to be registered.
Yes.
With that, we will examine his role, Mr. Raghu. His role, so far as the abatement of crime is concerned, if your complaint prima facie discloses, the police or you entitled to initiate appropriate action for registration for abatement of crime under section 306 or
yes.
306 only.
306.
See, so far as the liability of the state is concerned, for the vicarious liability is concerned, state is liable for two actions. One is payment of the compensation for illegal detention or custodial torture, and initiating disciplinary action against the officers who are responsible. So far as the respondents 6 and 7 are concerned, who has taken law into their hands, they are liable for the registration of the case against them. They are liable for the departmental action. They are liable for the payment of the compensation. These are the three actions we can initiate against those people. Therefore, I am straight away asking you who are representing the respondents 6 and 7 in this writ petition.
It appears they filed
Student. G. Anandam, SC for NIMS in place now Arun Kumar is appearing. S. Niranjan Reddy for R 79. 79 or 7 or 9. Who is appearing are the remaining respondents? Yes, Sunday.
because the counter file, I think that the commissioner has taken the responsibility.
Even then also,
Yes.
I don't want to proceed basing on that count. He might have taken responsibility as an officers to depose. When you made a personal capacity, his counter affidavit deposing in the official capacity does not helpful. Therefore, I will direct them to serve the personal notice to both the officers and report the next data. Yes, the respondents. The repetition has been can also take cognizance. Magistrate is entitled to prosecution. Magistrate.
In the offenses of criminal offenses, the medical corroboration is very important.
All this was continued before the magistrate, but there was a positive.
Magistrate.
The time of remand, in fact, they allege that, the reference custodial.
Now, in view of the report being placed by the report being called by this court.
Even the
See, the allegations is against even magistrate also. When a magistrate, it is the case of the petitioner, even after disclosing the custodial torture or illegal detention to the notice of the magistrate, instead of recording the said facts into the remand report, when he has not taken cognizance of the such statement being made with the petitioner, he was constrained to state the said allegations in the affidavit, and this court has taken cognizance. Do you mean to say that this court report is not valid then more than the magistrate recording? No, this court has called for a report from the concerned medical body constituted. Yes. Madam, don't think that this we will know everything how to deal with such cases. Yes. So far as respondent 6 and 9.
police.
Eighth respondent is CBCID adjacent to Mahavir Hospital, Masuptai. The petitioner hails from the Andhra state. Answer. What is the relief he is asking? Who is appearing for the petitioner? Mamuneni? Srinivasan. Yes, what do you say? It is pertaining to Andhra state. Yes. The Land Council reported the subject matter of the petition is pertaining to Andhra state.
Data as per the third
So what remains in this writ petition now? See, at the relevant point of time, that is on 10/4/2014, to know the genuineness, this court also exercised its discretion of directing the respondent police officer to be present before this court and having examined him personally. Therefore, nothing remains in this case. What is the main relief you sought? Question of the petitioner. Necessary steps in according, Honorable Court may please to direct second respondent take all necessary steps according to law, restoring the position. Can it be permissible in the writ petition? Even for a moment, assume that your position is an illegal, you have disposed it illegally. Still, this court is not having to redeliver the position under Article 206 of the Constitution of India. You have to, the moment whether legally or illegally you dispose it, only the proper course would be that you have to institute a suit for the restoration of possession before the competent court. Even we are having power under Article 226, still our powers to be rarely exercised. The reason is the restoration of possession requires some evidence. Therefore, we are not supposed to examine the evidence in the 226 jurisdiction, whether right or wrong.
As per the instruction the report was filed by the non-stop to take an action on the consultation of officer.
And without saying anything, I will simply close the writ petition. Randy. This repetition has been filed. Declare the action of the respondent. In sub. The person at your instance, the court has taken cognizance. Oh, you forget about the report. What is the present status? Because the court directed only 2 weeks status quo shall be maintained by both the parties. And meanwhile, directed to conduct an inquiry against the sub-inspector of police and place a record. And what is your instructions? Who are enjoying now this property? Some 2014, the property is under the lock and key. Who is appearing for the fourth respondent? Who is appearing for the fourth respondent? Nobody filed wakalat. Register seat cover పెట్టుకున్నాడు రిపోర్ట్ ఉందో చూడండి. అన్ని పెట్టాడు. Counter counter police at least. Nothing else is there, madam, in this case. I will leave it open. If any cause is there, you file an approved application revival of the case. Any cause survives, I will grant a liberty to file an approved application for revival of the case. Interesting.
On the petition, there was a statement of the democracy rule that there are civil disputes for the subject to the state property. Wherein it is exception that respondent in the interfering at the business of both
respondent. This court also directed to conduct an inquiry.
closed.
Next close. Item number 27, Mr. Ramesh Sagar. No, no. Just now we have seen the other case being disposed of. No. 2014, no instructions. Now we are in almost till 2023 ending. 10 years. First, let me see the record. If anything survives, definitely I will consider for granting a time. And even without even verifying the any cause survives or not, you are asking. వాడు దొరకడు నువ్వు లెటర్ రాసినా రాను కూడా రాడు ఇల్లు ఏం లేకపోతే సో ఫైల్ పట్టుకొని తిరగాల నువ్వు మొయ్యాలి అంతే యూ విల్ సీ ఎగ్జామిన్ ఇఫ్ ఎనీథింగ్ సర్వైవ్స్ ఆర్ ఆన్ yes madam what do you say you are not proceeding with any construction of culvert work what is his case if his property is required follow the procedure that's all if the property of the petitioner is required you follow the procedure as contemplated yes this petition has been filed saying this on to seek your direction to the respondents in proposing to construct a culvert. Mr. Bowson, yes, the Dalal government on instructions would submit the formation of work and CD works, bucket 23 numbers are completed.
electronic instructions Milad, no survives as per the results in the year 2014 Milad.
No car survives. We'll record the government period statement. This repetition has been filed. Seeking following. Conducting of the examination for the trade test under AE, GAS, NCVT, semester part and అది కూడా ఎప్పుడో అయిపోయి ఉంటుంది అంత ప్రైవేట్ ఐటీఐల పంచాయతా ఇంకేముంటది ఇప్పుడు అయిపోయి ఐటీ అయిపోయి ఉంటుంది ట్రైనింగ్ చేసి ఉంటాడు పెళ్లి చేసుకుంటాడు పిల్లలు పుట్టుంటారు పిల్లల పెళ్లి కూడా చేసి ఉంటాడు ఇంకేముంటది ఇంకా ట్రైనింగ్ ఏం చేయమంటున్నావు శ్రీనివాసరావు నువ్వు అని కింద క్లియర్ గా ఇచ్చింది కదా ఐటీఐ కోర్స్ అని రిలీఫ్ షార్ట్ ఇది ఫాలోయింగ్ రిలీఫ్ అని కదా ఈ పిటిషన్ Yes, that is also there today. It is connected, listed as a connected number, but record has not placed. It will be listed tomorrow. Yes. That is there already. If you file wakalat, without filing wakalat, where is the question of reporting even? File a wakalat, spend at least 100 rupees for filing a wakalat. That is even deputy solicitor earlier there after appointment you filed any fresh wakalat? File a wakalat by paying 100 rupees. It will go to the benefit of the advocates only.
My name is reflected.
Don't bother about if your name is reflected, office will take care of the same. Yes. Yes, Venkateshwara Rao Vallabha. Yes, what do you say? Respondent. You are respondent who is appearing for the petition. There is no representation. What is the case, Mr. Counsel? Not recognizing Telangana Boxing Association as a registered body bearing registration number under Rangareddy district, state of Telangana. What happened? Is it recognized now?
Any coverage in police below decided.
ఏం అర్థం కాలేదండి.
పోలీస్ లోపల లేకపోతే ఆటోమేటిక్
The Panchayat Hindi, even after formation, he wants to continue Andhra Pradesh Boxing Association as one unit rather than it is being divided into 2 units for the Andhra and Telangana. That is the grievance. అప్పుడు ఆయన ప్రెసిడెంట్ ఉండే ఆంధ్రప్రదేశ్కు ఆయన టర్మ్ అయిపోయేదాకా ఒకటే ఉండాలి అని అన్నాడు. అది అయిపోయిన తర్వాత 2 కావాలంటాడు మళ్ళా, ఎందుకంటే ఆయన ఇక్కడైనా కదా, అంతే కదా, ఏం లేదు. Is the grievance of the petitioner is to consider the petitioner's representation dated 28/8/2014. Mr. Prabhakar. Yes, who is appearing? Hearing now, police protection, sir. Main case, disposal. Number 31, Suresh Babu. ఇలా 2 ఉంటాయి మేడం, ఇలా 2 ఉంటాయి, ఒకటేమో ఇంటి ఆర్డర్ కదా, ఫైనల్ ఆర్డర్ తెలుసు కదా, ఫైనల్ ఆర్డర్ ఓఎస్ ఫైనల్ డిస్పోజల్. Yes, this is relating what? In pursuance of interim orders or in pursuance of the final orders? Who is appearing for the contesting respondents? This repetition is right, seeking following belief. Which claims to be Item number 32, appearance, Sheikh Hussain.
Yes.
Warrant was not executed, it was issued in the year 2010.
Yes.
Just submission the largest would be additional officer. By the records as well, as per this written inspection, the warrant has not been received to the station house officer. As a result of that, it led to a lapse and we could not execute the warrant. Which was
Warrant has not been reached.
to the station house officer.
Warrant is filed in the writ petition also as a material papers. How can you say that warrant has not been reached?
Was taken verified twice by the officer. The lordship's order is before your lord's now.
124 in failure to honor the sentence committal warrants issued in criminal MP number 232, 293, 420, 210 in MC number so and so, 139 of 2001 by the additional family judge so and so dated 23/6/2010. Who is appearing for the petitioner? Yes, you are appearing for the petitioner, part in person. What do you say?
Warrant was issued by
BBC.
BBC court, not by the BBC court.
Bomb blasting
Bomb blast court.
family court come bomb blasting. Is the family court case when the warrants have been issued?
Warrant was issued.
Date of the committal warrant is dated 23/6/2010. Have you made the accused as a party respondent to the writ petition? You are appearing. Huh? Which petition?
IS. And the IS, that's the defeat by department, the IS by. Without any meaning or any profit. Without studying. They,
See, is it your case? You are not the accused in the crime. In MC number 139 of 2021. Have you complied the directions issued by the family court in MC number 139 by 2001?
2018.
What is the 2018? Whether MC is pending as on the date on the file. See, when there is no pending of MC number 1,
There was no warrant issued.
you forget about all these things. As on the date whether MC is pending.
MC is not, MC is 2001, MC was executed last, MP were pending.
MPs are pending as on the date.
Start pending. He says that the entire amount was paid by the sufficient tax to release the harmful code. He says that last year.
It's a two-fold. CC, which was charge sheeted, the accused are reputed now, and the MC as per my instruction is closed now. There is no pending as of now. There is a
But see, they are seeking implementation of the orders being passed in MC number so and so. Petitioner seems to have filed criminal MPs number 232, 293, 420 of 2010 for a seeking implementation. In seeking an implementation case, this warrant seems to have been issued for arrest because he has not completed the orders issued in MC number 139 of 2001.
Yes, but the warrants which have been issued, which has been relied by the petitioner is for the year 2010, and as per my instructions, in the year 2018, MC is closed. Which they are denying, right?
Two 2018 that.
No.
December 2018.
Yes, what remains? These orders have been passed in the year 2018.
4 cases. That is the MP order last year. That is sentence order last year. Passed by the under the each court last year. That was sent to the SP Mahabubnath sir and 30 PS TSHC. They tried counter that. They tried counter that.
After this only, this criminal petition has been taken up in 573 of 2010 in MC number 139 of 2001 and dated on 15/12/2018. That petition has been closed subject to the petitioner satisfying all.
మూడు ఎంపీలు రాష్ట్ర నాకు బాగా చేశారు పోలీసు వాళ్ళకి పంపిస్తాం రాసి ఇంతవరకు ఇంకో ఈసారి సపరేషన్ చేస్తున్నట్టే బికాజ్ డాక్యుమెంట్ లాడ్షిప్ డాక్యుమెంట్ రాసి ఈ డాక్యుమెంట్ డిబిసి ట్రాన్స్ఫర్ డాక్యుమెంట్ తీసుకొని
Yes, it is recorded in 15/12 చదవండి ఆర్డర్ అది 15 అది చదువు ఆర్డర్ చదువు నువ్వు పంచాయతీ ఎందుకు పెడతావు చదువు.
The respondent has paid 13,250 also. 2,050. The petitioner. This court correct calculation in the claim made in this petition and in return MP 573/2010. But 573/2010 Rashi already sentence for issue అయింది రాసి
చదవండి ఆ ఆర్డర్ చదవండి.
22 and 18/2017 6 MPs last. Then in the presence of both the parties and their counsel, this court made calculation from 29/12/2001 last.
From 29/12/2001 to 28/2/2018. That means 2010 the pending applications also have been taken into consideration by the court. That means 2010 pending amount also has been taken into consideration. It is 29/12/2001 to 28/2/2008 to the petitioners 1 to 4 restricting the claim of the petitioner 2 to 4 up to their age of majority and arrived. Then you read
13,250 pages. Pages entire amount pages Asa transfer.
Sir, I'm dismissing your petition. Name లేదు ఏం లేదు వారెంట్ లేదు పోలీస్ లేదు ఏం లేదు అదంతా అయిపోయింది ఆ స్టేజ్ అంతా అయిపోయింది 29/12/2001 లో స్టేజ్ అయిపోయింది 15/12/2008 మళ్ళా అక్కడికే ఫ్యామిలీ కోర్టుకు పోయి ఏమైనా పే చేయకపోతే ఏమైనా డిస్ప్యూట్ ఉంటే ఏం బ్యాడ్ ఎస్ కౌంటర్ లేదు ఏం లేదు పిటిషన్ హస్ బీన్ ఫైల్డ్. యువర్ కేస్ ఈజ్ ఓవర్ ఆల్రెడీ. మీకు మళ్ళీ ఏమైనా ఫ్రెష్ గా బాకీ ఉంటే అప్లికేషన్ వేసుకోమన్నా ఫ్రెండ్. అయిపోయింది ఇక అయిపోయింది.
2001 సెకండ్ ల్యాండ్ చేసుకుని 2001 నుంచి 2014 వరకు outstanding ఉంది. Balance పంపిస్తే వచ్చి మొత్తం పే చేశానని DD
అదే అక్కడ కింది కోర్టులో చెప్పాలి మీరు, ఇక్కడ నా దగ్గర కింది కోర్టులో చెప్పాలి. అక్కడ మళ్ళీ ఒక ఎంపీ, అక్కడ మళ్ళీ ఒక ఎంపీ వేసి చెప్పాడు ఇట్లా సపరేట్ చేసిండు అది ఇక్కడ ఏముండదు, ఇక్కడ ఏముండదు. ఎస్
Item number 33, 34, 35. Yes.
I am appearing for the petitioner.
You are appearing for
Petitioner.
I appear in item 34 minutes.
Yes, what is the matter?
Millards, these matters are pertaining to HCA Millards. I am instructed to take an adjournment for 2 weeks Millards. I'll come up with an amendment application.
No, what is the matter? What is the relief you have sought in the HC?
The relief is sought against the single member committee Millards. I am
Now the elections are completed.
Elections are completed, but the relief still remains Millards. I have to amend the party. The new committee have come up. So I have to implement the new body Millards. That is my respectful submission.
But what is your grievance in the red petition?
That firstly, my name was deleted from the for the elections Millards. I was
Now elections are over. Now the elections are over. Ultimate prayer
elections are over, but still I remain de-affiliated to the HCA. Therefore, Millards, my representation has to be considered by the HCA new body. I am told that they are considering all such applications. I may come up with the amendment application is my respectful submission.
The demand, sir. Supreme Court order. The application in view of the reference of single member committee, the application does not survive for consideration with the same stance dispute. The pendants of any application before this court will thus not come in the way of single member committee in proceeding with the mandate to hold elections. This is with regard to the elections.
This I have only passed.
1 minute. Yes. What order? Yes, where is that finding? It appears that contrary to the intent of our order to put an end to the mess which was going on in the process of working of the single member committee, in appointing Mr. Sampath Kumar to assist him to the election process, various parties have been approaching the High Court and seeking different orders. Some proceedings have also been filed before district courts. In our view, no such proceedings could have been initiated at all. If there were any grievance, the only remedy lays before this court. The result, therefore, said is that we restrain the High Court and district courts from passing any order for the working of the single member committee. And if orders have been passed, the same will not be given effective. It is made clear that these orders are specifically passed today in pursuance of our jurisdiction. Yes, under 142, the Supreme Court exercised in the power. Where is the question of we are entertaining now 226, Mr. Counsel?
No, my respectful submission is on last occasion I passed this order to your lordship.
Whether you see, Mr. Dharmesh, you are not aware. See, in fact, I have interfered with the orders of the single member committee.
Yes.
I have directed the chief election officer to exercise his power, taking into consideration of the regulation 33 of the Hyderabad Cricket Association regulations on consultation with the single member decision. That was an order being challenged before the Supreme Court straight away, even without filing an appeal before this court. And Supreme Court interfered, and Supreme Court said in the result, we restrain the High Court and District Court from passing any order for the working of the single member committee. Therefore, if you are having a grievance with regard to the orders being passed by the single member committee, excluding you as a member of the Hyderabad Cricket Association, you go before Supreme Court, file an appropriate writ petition.
My respectful submission is the single member committee has filed a report now before the Honorable Supreme Court. The role of the single member committee is over now. So therefore, I'll come up with an amendment application is what my respectful submission. That report is filed before the Honorable Supreme Court.
So as long as, 1 minute, as long as the single member committee report is in force, The single member committee report is in force till the elections being conducted to the Hyderabad Cricket Association. Single member committee has determined who are the eligible members to be participated in the Hyderabad Cricket Association. After determination, election officer has been appointed. Election officer has been now conducted the elections. Therefore, his grievance is, since single member committee has excluded as a member of the petitioner club as a member to the Hyderabad Cricket Association, that will be taken into consideration of elected body, and he will make appropriate representation to the elected body. If he is eligible, that will be considered. Otherwise, it is not. If you want, I can dispose of allowing you to make a representation to the.
Yes.
అలా దానికి సుప్రీం కోర్టు తీసుకుపోయి లేని పొందాలి నొప్పి నాకెందుకు సార్ ఎంట్రీ ఆర్డర్ మీద డైరెక్ట్ సుప్రీం కోర్టు దాకా పోయినకు. Let you take steps of filing an amendment application and we will hear the newly elected body of the Hyderabad Cricket Association. If they say that they are going to consider your objections of being elected body now, then I will dispose in terms of their undertaking.
Yes.
Why should I list these cases? You get instructions from the elected body now. Now you are repenting to the elected body. There is no single member committee now. You get a written instructions that you will consider the duly taking into consideration of the objections or representations of the petitioners being included as a members of the club. Then I will record your statement. I will close the writ petition.
That is also a question, Millets, whom they are appearing for. Whether they are appearing for HCA.
See, unless you added them as a party respondent elected body, you are not supposed to appear now. You are repenting whom? No, HCA is not repented by the single member committee. HCA is now repented by the elected body. With the elected body has authorized you to repent the cases at least. Now I will close the writ petitions. You file, give a fresh representation and file a fresh writ petition instead of keeping these writ petitions pending. In view of
my lord may give that liberty and close it to make fresh application to the elected body.
It's better. Why all these disputes? This writ petition has been filed.
Mine is item 34 minutes 21635.
All the writ petitions.
Common order.
This writ petition has been filed with the praying this court. These writ petitions are this writ petition has been filed praying this court to declare the action of the respondent number 3 in a high-handedly barring the petitioner club and its executive committee members from holding office of respondent number 1 or contesting elections in respondent number 1 for the next term or for a period of 3 years, whichever is earlier, whichever is higher, when order stated 31/7/2023 as being untenable, legal, unlawful. The Honorable Supreme Court appointed the third respondent as single member committee. There is that my earlier orders in this case, single member committee, essential and personal.
Was in my writ petition, page 193.
The Honorable Supreme Court, special petition number 6779 of 2021, appointed single member committee for its order dated 14/2/2023 to ensure fair and proper elections are conducted to the apex council of the respondent number 1 and to administer the affairs of the association. In compliance with the directions issued by the Honorable Supreme Court, the third respondent herein has appointed the election officer and election officer after verification of the eligibility after the election officer after preparation of electoral after election officer after exercising powers under clause 33 of Memorandum of Association of Rules and Regulations, after preparation of electoral after preparation of voters list and conducted the elections. Elections conducted the elections to the first respondent on 28/20 on 20/10/2023 and consequently the newly elected body also assumed the office of the first respondent. In view of the same, the relief sought in this petition no longer survives for any further adjudication. However, liberty is given to the petitioners to make appropriate representation to the newly elected body if they are having any grievances. And if such an application is filed, the newly elected governing council is directed to consider the same in terms of the orders of the Supreme Court. And also, there is no orders. Any orders are there of the Supreme Court now?
As far as my instructions are.
Before apex court, it is coming. Emma.
If such an application is filed newly elected.
See, now the matter is coming before the Supreme Court. They will report before the Supreme Court.
No, that's what I said, Milaj. The single man committee has filed the report before Supreme Court. The matter will come up, the report will be accepted and he will be discharged. That's all.
Therefore, you want to keep these petitions pending for further?
No, as your lordship said, it can be disposed of, Milord, with a direction to the newly elected body, because my status has to be decided.
You are right, but the Supreme Court, once again, if interferes saying that once we have seized up the matter in SLP, and when we have...
Then your lordship may have it after 2 weeks. I'll file immediate application. I'll file amendment.
This order can be passed subsequently also. Restrain
Yes,
the High Court from passing any order. Then unnecessarily...
It may be adjourned for 2 weeks, Milord. It may be adjourned for 2 weeks.
List these cases. Yes, list these repetitions for a hearing on 21/12. Yes.
Obliged.
Order the share. Coming for? When the counter was served on you? Seventh of this month? Yes, sir, the request of the Land Council. What is the matter, Mr. Prabhakar? It is, according to me, it seems to have been covered. What is that, according to citizen?
According to section 32, Telangana accepts 60, your lordship. No remission for closure is there.
Have you filed a counter?
Yes.
You file a reply? Yes. Release this case for filing reply. 14/12. Yes, Mr. Prabhakar.
I also submitted.
This is election time. I am not entertaining my discretion to close the rowdy sheets.
After election. 2019.
No, I will allow the writ petition after the elections are over. You wait for the passing an order. List this case on 5/12. Why orders it? Once again, it is keeping pending unnecessarily with me. List this case for orders on 5/12. See, how many permissions are you required for Sadar? Each and every place you want. అదే YMCA కాడ అవుతుంది కదా సదర్ ఎక్కువ. One is the YMCA, other is? Then? No, that is not there earlier. You are a council from Hyderabad, native. You are a, which place you belong to? You are a council from native of Hyderabad. We never heard that this other being conducted at other places than the YMCA and Secunderabad. There are only two places. Last year you have organized. Yes, what do you say, Mr. County? Where is the rejection order? See, where is the last year permission? Where is the permission granted by last year? Right? So what do you say? What are your instructions? The lunch motion today morning they have served the papers, so I have been getting instructions tomorrow. What is the difficulty for today and tomorrow? Yes, this case in tomorrow motion list. Get instructions from the concerned officer. Is there any law and order problem? Dispose just of Raza.
Number 38. Yes. And the objection brought to that and find the speculation and the note is issued by the survey department. I have filed this cause.
USR number?
And
18/10/2023. That is over. Oh, what is the next date? Page number?
Notice issued by the survey department.
Page number? 1811. Yes, provided already. Yes.
In last issue,
Next date is 1811. You provide 1811. Now elections are there 1811. Whether it is possible, sufficient police force is available or not, we don't know. Yes, right. Have you filed any writ appeal questioning the orders passed by? Then having not filed the writ appeal, how can you state in a writ petition now? See, have you filed any appeal? See, where is the order of this court? Page. See, have you filed any writ appeal questioning the orders passed in WP 33152 of 2022? Having not filed, where is the question of now you are stating that issue before this court? Yes. What is the matter? Effective? Yes, what do you say? They have already filed charge sheet. What is there? You file an appropriate application under section 216 CRPC. If there is no fair investigation. Yes, sir, the request of the petitioner, I'll list this case on 21/12. Your number 40 is Arun Kumar. What is the negligence in discharging official duties? They have not followed. What is that SOP? What do you mean? SOP means what? Issued by whom? For which provision of law the commissioner is having power to issue such a circular? What is the legal sanctity for issuing of such a circular? Is there any legislative sanction to the commissioner to issue such a circular? Under which provision of the commissioner is having power? Under which provision of law? For example, if you say that inherent power under criminal procedure code, courts are having power under section 482. Civil courts are having power under section 151. High courts are having power under 226. Supreme Court is having power under article 142 and read with 32 of the. Show me the power of the commissioner under which provision the commissioner has gotten an inherent power. Section 32 of Hyderabad City Police Act. Hyderabad City Police Act. Whether Hyderabad City Police Act is applicable to this.
Yes, yeah. Police Act is
Where is that SOP filed by? Have you filed SOP?
Exhibit even material page number 13.
Page number
13.
Yes.
Officers in charge of violated the guidelines in respect to the dispute type submitting and posting.
Page number 13. You have only it is an affidavit. It is your affidavit.
Exhibit P1.
Exhibit. Yes. Yes. So what is that relief you are asking in this petition? Mr. Arun Kumar, what is that relief you are asking in this petition? You submit a representation to the commissioner.
Yes,
according to you, in violation of the SOP guidelines issued by the commissioner of police, they have registered the case. That is your grievance.
The case where my lord the petition before you are advanced the sum of is about 2 crores to respondent number 10 during the month of October 2022. And the respondent number 10 has offered his property as security to the loan accommodation transaction, registering a sale deed in favor of the petitioner.
That means to say that it is a mortgage deed.
Yes, not mortgage, but direct sale deed he has executed with a request to repay the amounts given by the petitioner.
Can any sale deed can impose a certain conditions? Sale is an absolute transfer.
There was no condition in the sale deed.
It's oral understanding.
It was only an oral understanding between the parties. It was agreed by the respondent number 10 to pay the amount within 3 months. The petitioner before you have waited till April 2022. And in the first week of April 2022, the petitioner approached the respondent number 10, seeking him to repay the amount and get a reconsideration. that juncture, my lord, before the petitioner, this respondent number 10 has filed a false complaint before the PS Malkas meeting, and thereafter, under the guidance or under the advice, police approached the city civil court, filed a civil suit for cancellation of the city, and then got political influence done for some reasons beyond the control of the petitioner and got the matter settled as it is a mistake of fact within a span of 2 months. And that the SHO has in fact noticed that there is a lacuna in the points what we have given a reply to for 41.
So what is that you want? Tell me. మీకు ఏం కావాలని నేను అడుగుతాను మొత్తం చరిత్ర చెప్తావే. What is the relief you are asking in this writ petition?
Declaring the action.
In this court is having any power to settle the disputes inter se among the parties and direct the private parties to pay the compensation when they are not discharging any statutory duties.
It's coming in the way of the petitioner on the clear question. My intention is that I have nothing to the question figure like anything asking the authorities to look into the grievance wherein I have defrauded and the police have caused the convenience to the.
How you are defrauded? You have executed a sale deed, a registered sale deed.
My amount was struck to
Have you executed the registered sale deed or not?
bonds with me. I have promises also.
Go before civil court if you are having a bonds and file a institute appropriate suit for recovery of that amount.
Having understood that I have acute party for the concern was directed by the complaint.
The SHO is not having any power or authority to decide the civil disputes. SHO is not conferred with any power or authority. He is only an authority to act in accordance with the criminal procedure code. That's all. He is not.
My grievance is that the fraud was played on me. On that ground, I have filed a complaint.
Why you read your complaint? What is that complaint? Your complaint discloses. Where is that complaint? 73. Yes.
Report versus previously, this was the data actually also has been introduced to me by what we consider sir. Who is a businessman by occupation, scientist by education, and director of business to also
Says what is that action you have taken on this complaint? Yes, counter it. What they have stated in their counter affidavit?
They have responded by only here reply and others despite the duties and where is court have not come before court filing their counter.
What is this crime number 319 of 2022? It is registered against whom? Acting on the complaint of the petitioner, you have registered a crime also. Is it your case? Official respondents lodged a complaint against the petitioner. Which respondent? Who is the respondent number 10?
Is the person who is the beneficiary of my.
Can all these things can be decided in the red jurisdiction?
I have completed I have given my complaint. To go to the assistant commissioner. Assistant commissioner again asked me to go to the commissioner. Again they said that we go to the police station. Having come to understanding that there was negligence in the case, technology that has rectified it to the best level, They have been playing.
See, why can't you approach the competent criminal court for filing a private complaint under?
Even if I approach the criminal court, same jurisdiction police station will be referred the matter.
But once the complaint being referred by the competent magistrate, prima facie satisfying that the allegations leveled in the complaint discloses a cognizable offence, it is mandatory on the part of the respondents to follow the procedure prescribed in Lalita Kumari case. And even if the police have not taken cognizance in such a cases, you are directly entitled to file a complaint on the file of the magistrate. Magistrate would entitled to take a cognizance and by issuing a summons to the contesting parties therein. You can straight away file a complaint on the file of the magistrate. It is a quasi criminal, quasi civil. Why you are depending upon the police?
There is a lot of delay. The moment that FIR was filed, final report was filed, immediately we have filed a complaint to the court and they have filed it and returned it. And thereafter, when the before you asked the court to go before the court, the same message to court and ask you to file the complaint. So that
There are two options for you. One is I will dismiss the petition with cast. Other is I will allow you to state your grievances before the appropriate forum. Which option you want to choose? This is not a case of where this court can exercise its discretion under Article 226 of the Constitution of India. There are purely civil disputes interstate parties, execution of the documents, non-payment, execution of the bonds, promissory notes, and it is for you to go before a competent civil court for recovery of those amounts if somebody has paid a fraud. Even if you, without paying of any sale consideration, the sale deed has been entered, executed by you, you institute a suit for cancellation of the sale deed saying that it is a sham and bogus sale deed and you have not received the sale consideration. Therefore, sale deed executed by you has to be declared as cancelled. You are having so many relief to state before competent civil court. Why you want to invite this court under Article 226 to give a finding against either of the party? I am not supposed to give a finding against either of the party. Sir Counsel, I have gone through your record. I have given two options to you. Which option you want to select? Select it. No, I have already heard. In Kamala instructions in the party is not supposed to advise you. You are supposed to advise party. You are a counsel to the party. How can you act upon the advice of the party? You are here to advise the party. I will leave it open to you. Yes. Petitioner. Who is non-appearance? When I am not attending on the, to dispose the petition on merits, that is not having any impact over the issues. See how many reliefs you have sought in the petition. Can such by seeing the reliefs it has to be dismissed? Can such a omnibus reliefs can be granted by this court? The petitioner filed the present petition. What is that crank?
The information given to that. Was ordered by Wow, and was created an accident. Then the recommendation made to
How you came to know it is in a murder, it is not an accident? The circumstances have been taken care by the police by conducting inquest report and Panchanama. See, what is the forensic report, Mr. Counsel? Bonafide. Have you filed any counter in this case? Is read relevant portion of the counter affidavit? Paragraph. 1 minute. This paragraph. Yes.
During the course of investigation officer examined the complaint, second testament, some others recorded their detailed statement. It is respectfully submitted that this civil assistant area hospital with the dead body and the deceased.
What do you mean that polytrauma and head injury and polytrauma? What do you mean polytrauma? Mr. Wahed is a pillion rider of the vehicle. Whether he has received any injuries? See, even Wahed, who is a pillion rider, also received a grievous injuries. You read the counter affidavit being filed by the respondent. Injuries sustained by him are grievous in nature. You go before the competent criminal court file if you are having any additional material. If you feel that still the investigation has not been properly conducted, there is a lapses on the part of the investigation agency. Forget about representation. You go before the competent court, file an appropriate application under section 216 CRPC. Page number? Page of the counter affidavit. From how you got the PME report, postmortem report? It is a document furnished to you. Yes, read the relevant portion of PME. Page 30, yes. మృతుడు రోడ్డు ప్రమాదంలో ముఖానికి మరియు it is pressed private parts. మృతుడు రోడ్డు ప్రమాదంలో ముఖానికి అంటే ముఖాన్ని ఏమంటారు ఇంగ్లీష్ లో? It also say that head. It is part of the head only. Face is also part of the head. Yes. Therefore, you state all these issues before the competent civil court, competent criminal court. Page 31. Yes. See, in this last four lines you read. తలకు ముఖానికి మరియు అండ్ ప్రైవేట్ పార్ట్స్ తీవ్ర గాయాలై ఆసుపత్రికి తరలించి చనిపోయాడు. వాట్ ఈస్ రాంగ్ ఇన్ ఇట్? ఎస్. Therefore, you state all these grievances before the concern. No, I will give you a liberty you to file an appropriate application before the concern. What is the reply? Yes. Since the pleadings are completed in this case, pleadings are completed in this case, list this case for hearing in the month of January. Yes. Let them file it since pleadings are completed. You don't want to dispose the case. Yes. You argue at file hearing. Yes. January holidays tarvata. Go date. Yes.
Number 43, Mr. Mohammed Muhammad Basu. On number 5 to 7 is appearing for.
May I please, Your Lordship? May I please, Your Lordship? I am appearing on behalf of petitioner, my lords.
Yes.
I am for petitioner, my lords.
Yes.
Respondents have to file the counter, my lords. Last time the short time for filing counter is.
You are appearing for? You are appearing for?
5 to 7 and 10 crores.
What do you say? What is the matter?
Yes.
In fact, the facts of the case are like this. Both the petitioner as well as the respondent, they filed the suit. And already the civil suits are pending. In fact, there's an allegation by the petitioner saying that we are trying to involve the police. In fact, since the lordship now kindly come to page of my counter, yours, page 69, yours. Page 69 of my counter.
Yes.
But the last para 30
Yes.
I mean, committed.
Yes.
In other words, as by the Ugandan itself, 7.26 of company was parted, parcel of Suda final and the same is referred in the sale is executed in favor of the petitioner and respondent to Bank 3 and the vendor. Therefore, the ex party interim order continue to operate as per dated to answer and undue the hardship will be caused to petitioner who are required within plots as per the UDA final layout referred above. Therefore, the discretion.
This is only with regard to orders passed in I.
What I'm saying is both have filed the suit and the matter is pending there. In fact, there is no interference from the police.
Yes. Mr. Kadri, I am closing the writ petition. I will direct the police not to interfere with the civil disputes.
Yes, my lords.
Yes. Why should I say cooperate with the investigation? If they have not cooperated, criminal procedure could prescribe the procedure. Therefore, you initiate appropriate steps in if they are not cooperating with the investigation further. Why should High Court has to record to cooperate with the investigation? You are bringing the High Court as a lower level of municipal state level. Therefore, yes, ready. This writ petition is filed for seeking following the list. Petitioners claims to be lawful owners. Petitioners claims to be owners and possessors of the land bearing survey number land to an extent of 0.13 guntas in survey number 286, Kumpelli village, Gandimaisamma, Dundigal Mandal, Medicine Malkari district, having purchased the same under registered sale deed by document number 1560 of 2018, dated 2/2018. And it is further case of the petitioner since the date of purchase of the said property, they are enjoying the same as absolute owners and possessors. It is the contention of the counsel for the petitioner. It is the contention of the petitioners and that their vendors and their predecessors in interest are the absolute owners, and their names are also depicted in all the revenue records as Pattadas. It is further case of the petitioner that neighboring landowners have developed the adjacent land to the petitioner. And started interfering, and to protect the petitioner's possession of the property, petitioner has constructed watchman rooms fencing the subject land and also obtained the power supply connection from the electricity department. Then even after the protecting the property, when the respondents are continually interfering, the respondents 5 to 11 are continuously interfering with the position of the petitioner. The petitioner was constrained to institute OS number 245 of 2022 on the file of the principal senior civil judge Merchant Malchar district seeking perpetual injunction. The said court also granted additive injunction by order stated 13/12/2022. The grievance of the petitioner in this petition is that at the instance of the respondents 5 to 11, the fourth respondent is frequently interfering with the position of the petitioner and forcing the petitioners to enter into a settlement with the respondents 5 to 11. 11th counsel appearing for the petitioner vehemently contended that the fourth respondent is not having any power or authority to interfere into civil disputes pending between the petitioners and respondents 5 to 11 in any manner. And the action of the respondent police interfering in civil disputes amounts to violation of the rights guaranteed to the petitioners under Article 21 of the Constitution of India. The 11th counsel appearing for the 11th counsel after receipt counter affidavit has been filed by the 11th counsel appearing. Counter affidavit has been filed by the respondents 5 to 7 and 10. It is the contention of the respondents that they are the absolute owners of the land having purchased the same, though registered sale deeds. When there is a dispute with regard to identification and localization, localization and classification and fixation of the boundaries of the lands purchased by the petitioners and the respondents herein, and lands purchased by the respondents with that of the lands purchased by the petitioner, they are constrained to institute a suit by OS number 116 of 2023 on the file of the second additional district judge Merchant Malchar district. The suits instituted by the petitioner as well as the respondents herein by OS number 245 of 2022 and OS number 116 of 2023 are pending for adjudication as on the date. It is further contended by the land counsel for the respondents that in the petitioner has made the petitioner making false allegations against the fourth respondent that he is interfering with the civil disputes. He is trying to interfere with the position of the petitioners. And in fact, the land government pleader appearing for the fourth respondent has submitted that in view of pendency of the suits, the fourth respondent has not interfered with the position of the petitioners or the respondents in any manner. And if either of the party files a complaint which reveals a cognizable offence, they will initiate appropriate action in accordance with the principles of court. In view of this submission, this court deems it appropriate to dispose of the petition directing the fourth respondent not to interfere with the civil disputes pending in OS number so and so and OS number so and so on the file of the court of the so and so. And in the presence of the petitioners or the respondents are for the purpose of investigation, the respondents are directed to follow the due procedure of law. The above observation, the petitions are disposed. Item number 44. Yes, Saifullah. Ram. No repetition 21/9/2023 and the matter was taken up. This court headed Matter was directed to be listed on 9/11/24. Today also there is no representation on that. Dismissed. Yes. Ram.
May I please, my lord?
Yes.
My lord, this writ petition is filed, my lord, to alter the sections.
You are representing?
K. Kiran Kumar, my lord.
See, why there was
Petitioner.
no representation on 31/8/2023 and 21/9/2023 on your behalf?
I was not feeling well, madam.
So you have to make an alternative arrangement of requesting some counsel to represent the matter before this court. When you are not feeling well on particular day, as and when you feel well, you will make a representation is not the concern of the court.
Apologize, madam. May I apologize?
Yes. What is your case?
My lord, to alter the sections as 307 IPC, my lord, instead of 324 IPC, my lord.
Or criminal court file an application under section 216 of the CRPC seeking alteration of the provisions. The criminal court is having always power before pronouncement of judgment. At any time, the court is having power to alter the provisions of law.
My lord, writ petition is also maintainable, my lord, when my fundamental right under 21 is infringed, my lord.
It's not
Because,
almost it is not almost to violation of the fundamental right. Fundamental right would come
my
case has not been registered. When case has been registered, this court is not having any power to overcome the procedure prescribed under the criminal procedure code. You go there.
My lord, my complaint discloses the attempt
Therefore,
to kill, my lord.
the competent criminal court is always having power. Read section 216 what it says. Read, Mr. Counsel. Therefore, he is entitled to file an appropriate application on the file of the concerned court to alter the charges. The court is having power at any time. The court is before pronouncement of judgment. Court can alter
Liberty to file before
Why
the.
should I grant a liberty when you are having a right to file such an application under the provision of law? Yes, right. This writ petition is filed. Seeking following relief. Relief total amount is therefore paid. The case of the petitioner is that he has lodged a complaint on 9/3/2023 on the file of the third respondent. Who lodged a complaint against your husband?
Sorry, my lord.
Who lodged a complaint against your husband? You are not the de facto complainant.
The petitioner, my lord. I'm the de facto complainant is a petitioner.
De facto complainant is the petitioner.
Yes, ma'am. Sabhavat Jyoti.
The complaint was lodged by the petitioner. And you have lodged a complaint against your own husband.
Yes, my lord. Because he was trying to kill, my lord.
He has lodged a complaint on 9/3/2023 on the file of the third respondent against her husband, stating about 19 years back, stating about that her husband is making attempts to kill her. They demand to bring additional doubt. Basing on acting on the said complaint, the case was registered in crime number 498A read with 324 IPC. The grievance of the petitioner is instead of the petitioner has received serious injuries and the injuries discloses the ingredient of section 307 IPC. The police instead of registering a case under section 307 IPC, they are registering a case under section 324 IPC. Read with section 324 IPC. Therefore, there is no proper and fair investigation being conducted by the respondent police. List. The land down period appearing for the respondent is submitted. after conducting the investigation, they have laid the charge sheet against the accused in the said crime. Accused in the crime number. What is that crime number?
53 of 2023.
Crime number 53 of 2023.
1893
Under section 498A, 324, 34 IPC. The grievance of the petitioner is the police have not conducted fair and proper investigation. And in fact, against the respondents, when the complaint of the petitioner discloses ingredients of section 307 IPC, they are to have invoked the said provision against the against the accused in the said crime. This court is of the view, since the petitioner is having a remedy of filing appropriate application under section 216 CRPC for seeking alteration or addition of the charges at any point of time, pending adjudication of the conclusion of the trial, granting a liberty to the petitioner to file an appropriate application on the file of the concerned court. This petition is disposed of. If such an application is being filed by the petitioner, the court will is directed to examine the same strictly in accordance with law and to examine the same in accordance with law and dispose examine the same.
Much obliged.
Number 46, Mr. Amara.
Yes, Mr. Amara. No. Who underwent surgery? Mr. Amara underwent surgery. Yes, at the request of the land counsel for the petitioner. List this case on 21-2.
Please, Lordship. May I
Yes.
please, Lordship?
Yes.
Lordship, one week time may be given, Lordship, in this matter, Lordship. Because I have to file some few documents, Lordship.
See, you are entitled to file whatever document you are in possession at the time of filing of the writ petition. Or if subsequently you secured any of the document, you have to file an application with a permit explaining to the court that documents are not in your custody at the time of filing of the writ petition. And the writ petition would be normally filed for violation of Part 3 of the provisions of Part 3 of the Constitution. And this court always having power to take cognizance of the violation of the fundamental rights of the citizen at any time. What are those documents you want to file?
Lordship, in this matter, Lordship, FIR was registered on the name of Aminuddin, Lordship. But the police people are trying to arrest Minajuddin, Lordship.
Yes, what do you say? Aminuddin and Mirajuddin is one and the same. That is your case.
No, Lordship, the both are different, Lordship.
If both are different, you file a discharge petition before the competent court. Why you are asking a quash proceedings in a writ jurisdiction under Article 226 of?
Lordship, I filed that one also, Lordship.
What happened to that discharge petition?
That is pending, Lordship.
Then while pending the discharge petition, how you are entitled to maintain a writ petition on the similar relief? And you have stated in the last paragraph of the affidavit, you have not invoked any of the court for the similar relief. Having filed a revision, have you stated in this affidavit you have filed a revision?
That was withdrawn, Lordship.
Because there you have not succeeded, they have withdrawn. You are expected to succeed in this writ petition, therefore you have filed a writ petition. When a revisional court is not in a position to examine, it being the competent criminal court at the lower level, how you are expecting that High Court will go into all these issues? And what is that evidence you have placed to say that you are not Naziruddin and you are Mizaruddin?
That's I will file the Aadhaar card and passport details, Lordship.
Filed at the time of filing of the writ petition?
No, Lordship.
Then how can now you file? How you are expecting? Once you file a petition, respondents have already filed their counter affidavit.
Yes,
after
Lordship.
filing of counter affidavit, you are not supposed to file any material which is having an impact over the decision being taken by the court. It amounts to new pleadings being brought into existence by way of a reply affidavit that can't be allowed in the writ jurisdiction.
1 week time may be given, Lordship. My humble request.
You have not stated that about filing of revision and withdrawing the same. Where you have stated? It is not amounts to suppression of the fact. Read your affidavit where you have stated about filing of the revision on the file of this court or on the file of the trial court. Nowhere you have disclosed in your affidavit. Yes, at the request of the land counsel for the petitioner. Is this case 21-12? There is no urgency in your case.
Number 588 is Mr. Rajshekar.
Yes, what is the matter, Mr. Rash?
Yes, my lord, 49 item 59 is a criminal petition. It is connected with 48.
Yes.
The offences in which arrests are, my lord, under section 304 EID. But above, my lord, because the influence sexual charges 304 part 2, they are right charge. So now I am facing trial before the sessions. My learned submission is, my lord, my respective submission is that I should be tried only under section 304A and not 304 part 2.
You can hesitate your claim before the very same court also by filing an appropriate application.
My lord, even before the application I had to file an application. My first petition is pertaining to year 2000.
Is there any stay in the cost proceedings? 21. My petition is 21, 2021.
Recently, my lord, the charges have been framed, my lord, and since there was no stay petition.
My petition is filed questioning the first information report or the after filing of the charge. Charge CC.
I'm questioning, my lord, that I should have been charged in the section. The charges should have been framed. The session should, the court should have rejected them and sent it no to the legislative court because it is their jurisdiction, not my jurisdiction.
If that is the case, they are entitled to file a revision if the sessions court is rejected, but not the.
There was no petition there because even before I had to file the petition, my petition here was filed. So therefore, my lord, this petition, case number 49 needs to be heard first. For any reason,
It's a case where legacy petition has been filed.
48 events of the petition is
Initially, I have granted stay. This is very same case.
48 is not certain because entire stay has been found. The case of the is that the special public prosecutor was appointed. It's not a case of appointment of special public. It's an entrustment of work to the public prosecutor.
To discharge what for?
For conducting the trial in this case. But this is a sensational case where an expert army veteran was these proceedings are 302 section, my lord, because the accused in that case, my lord, he was in the pub still night. After one pub, he goes to another pub. And again, till morning, he drinks, my lord. In the early morning, 5:30, he rash and accident by this person and ranks away. And he takes efforts so that the evidence, there should not be any evidence.
Who is appearing for the respondents 4 and 5?
The director of iron office.
Respondent 4 and 5.
We filed our counter.
Yes. Who is appearing for 6th respondent?
Nobody is appearing. Nobody.
Notices have been served on 6th respondent.
Notice has been served around. He is officer. He is working with the office of the Director General of Police and additional SP. He is the person who has reached the spot.
No, who is appearing? I am only asking who is appearing.
It's not fresh, my lord. He is on the request, but he comes appointed to the High Court. Only to pursue this matter with the officers. Spot number 6, my lord. He is not the person who is requested for the appointment of.
See, there is a specific allegations being made by the senior counsel on last occasion. It was recorded that has made a sufficient that 6th respondent being the victim taking his position as additional superintendent of police in the office of the Director General of Police has influenced the 3rd respondents to appoint a respondent number 4 and 5 as an additional public prosecutor. See, if it is not a correct, he has to deny. He has to deny. Mr. When a party has been made, Ragolu Satyam Babu has been made as a party by name, who is appearing for him?
Request of another son, his name is Ratnababu. On his request, Commissioner of Police has requested the Director of Prosecution to appoint one.
So what is the role of even whether others are this 6th respondent?
CRPC, who double A,
Therefore, tomorrow onwards, we will direct all the victims to make a representation to the government to appoint additional public.
only in exceptional cases, not in.
How can you differentiate the case by case as exception? Every case is an exceptional case.
This is something different compared to.
You want to commence the arguments on the main writ petition.
There's two things. The wash petition that is item 49 already in case the lordships are allowing it. Then that will not survive because the matter will go to the ministerial court and probably they will have to make an application for a special public prosecutor because the special public prosecutor.
That is the reason why the criminal petition is posted along with the main writ petition.
That's what
You argue the criminal petition.
Criminal petition.
Yes.
The lordship can get the.
Yes, what is your opinion? Are you ready today?
Page 5.
1 minute. Yes.
Statements not filed in this case. All statements.
What statements?
Statements not.
See, if he has not filed, it is his difficulty.
Generally,
See, you are aware about the limitations of this court under Article 226 or 482 to the extent of the case law being laid down by the Supreme Court in Bhajanlal case. What extent this court is
even though the charge sheet itself, prima facie only 3 or 4
his contention is on the first ground of the Bhajanlal. He says a simple reading of the charge sheet, whether does it disclose any offense or not.
Knowledge of everything.
Then what is the botherness for you to filing of all the documents which are you are in possession of all the statements being the public prosecutor. Why you have not filed if that is the case? Who said that petitioner alone is entitled to? When you are defending the prosecution, you are entitled. You want to rely upon any of the statements which will support the case of the prosecution, you would have been taken steps of filing those documents. Yes.
Page 5.
Page 5.
Yes.
Yes.
Nothing in that. This is a case where
yes.
This is a case of culpable homicide, not about the murder and stealing of evidence. We checked out on 10, 12, 2006 at about 500 years straight. Here, Dushabad temple located on the road leading wherein the accused YouTuber of Prashant Kumar's particulars marginal documentation source. Drove his own vehicle number so the rash and negligent manner under the influence of alcohol and hit one pedestrian ex-army senior civilian knowingly that his acts may cause injury or death to a human life.
See, what is that the prima facie evidence being placed in support of the charge that the accused driving the vehicle was in the intoxication system? Except allegation, nothing else on being.
After 16 days, they catch it. They say that because they take out one small part of the vehicle related to the workshop of the vehicle where it is stationed.
No, I am asking Mr. Naishar with regard to examination of the accused is concerned. See, is there any evidence being placed on the record?
No,
or is there any? That is, I am asking the medical.
No medical report regarding the breath analyzer or blood test.
That is, I am asking. That is only I am asking in support of the charge. Except they are relying upon the circumstantial evidence to say that the part of the vehicle being found after 16 days in some other place.
On the spot.
The vehicle was not seized at the scene of offence immediately.
No, seized to the workshop after 15 days. And what they do is, my lord, they take out his cards after 15 days they arrest him. They say that on that particular night he was there in the pub. From the pub he seems to have gone to his girlfriend's house. There in the morning around 5 o'clock he was coming back home because he had to go home. He seems he met with an accident. And 2 kilometers away somewhere in the CCTV camera, this vehicle number is found. Not on the spot. So many vehicles are flying from that road on that particular time. Why only this vehicle?
But according to you, when there is no evidence being available on record, either it is for part 2 or 3A, you are entitled for an acquittal. Why you are bothering?
And
No, when you are having a case on merits.
Using the right to appeal before the sessions court. Suppose if I'm convicted, then I have to straightaway come to High Court and then one step I'm losing. Magistrate's commission is let them try my case before the magistrate court, before the chief metropolitan magistrate court. And let them make sure.
Yes, argue.
Why 302 is not to, it's not a murder.
So we can take out stay in the class.
Page number?
15.
Yes.
I will read in the second
1 minute.
the investigation.
Page number?
15, 1-5.
Yes.
Second paragraph. The investigation further laid the concerns of the entity whose father is questioning about the damage of short Opera which appears Prashant Kumar comforted there and him that crashing on road divider and the car got damaged. And they go to care the accused Prashant number. Rotates in front of and made from their car and from the in order to catch include the events. The offenses the exposure shifted the above car on body workshop in the base and the them not to disclose the details of to anybody. After that, they will report the extent to the central insurance company accounting the extent and claiming the amount from the state insurance company by distributing the impact that with passing out accidentally his car fell in road side it and got damaged and keep it in the above braking in 4 finger. Car number one. So say workshop. Investigation further revealed that the earlier due to the accident in the accident score for those put several times by the traffic police violating traffic rules and the accused person Kumar and the younger brother stand involved in the several road accidents, but they are cases in police station. Investigation further revealed that the accused person Kumar is educated in the
Is there any evidence being collected that before the accident night? Yes.
So engineering to cut money, being the educated, the accused cannot the person drive the car, motor vehicle in high speed under the influence of the alcohol may cause an accident to the road and resulting death of the patient and even though the accused following consuming the heavy alcohol in 2 places such as Force Club, Fight Club, Subril, Hyderabad. In the investigation night, so wait till early hours so after in the early morning about 5 AM, dropped with the 2 girls, Gauri and Yamuna Hills, playing apartments, Gachibowli, Hyderabad, 4 people. And car number so and so in that place, driving his car in accident in spite.
Mr. Naheshwarao, in hit and run cases, normally the only basing on the circumstantial evidence only any person would come to conclusion. But how can you say that in hit and run cases also the evidence must be available, eyewitness evidence or anything else?
I'm saying let them try. No, they are
But
saying
only
that-
for instead of 304D.
Why 304? Why I have not committed murder? I have committed rational negligence. I caused the death of that person. All that time of it is there. I'm ready to face. I'm not asking for questions.
Say what is that evidence you are having to say
That I committed murder.
rightly pointed out by the lens?
Want to drive, taking alcohol to drive and the case is there. So the people will not be able to give the people. They won't see clearly knowledge of the person. You go to high speed and look at page number 13 parameter.
High speed means what?
More than 40 above 100 speed is going now.
Is there any the board fix speed limit being fixed in an area of the scene of offense?
Yes, you have to speak so spotted.
Have you indicated the same thing? Where is that? Where you have stated in the charge sheet? That speed limit in particular area. Mr. Ganesh, it's a criminal case. Don't argue as a repetition. If you say that speed limit has been fixed in particular area, the vehicle was close such a speed. Is there any report being obtained from the transport department, that is motor vehicle inspector? Name kuda koni cases chesam. Show me the report being obtained from the. He is right, Learned Senior Counsel is right in saying instead of 304A, you have invoked you have invoked. Let you proceed under 304A. I will pass to the extent of 304B is concerned.
Trial law, stay in law. Trial.
It is extraordinary relief being given to the civilian under the constitution to enable him to question the CC after either be at the stage of FIR or at the stage of filing of the charge sheet to file a petition under section 482. He has rightly filed a 482. If he satisfied this code, for example, 482 would come into picture if an authority has wrongly invoked the provision. According to him, you have wrongly invoked the provision in the absence of substantial material to say that it is. He is agreeing that 304A, but his only dispute is with regard to 304 part 2. And how can you say that? And he is not even identify the person, and there is no any previous enmity between the petitioner and the deceased. To say that there is an enmity because of that, keeping in mind he has committed such an offence attracting to section 304B. See, what is that report you have placed to say that he has taken alcohol? You are saying alcohol. Where is that? Where is the investigation where you have stated? No. Your role is so far as the petition is concerned, appointment of. No. You want
statements of the.
You are not supposed to argue. Your home GP, PP is here. He will satisfy. That is your role to the extent of PP appointment only. You are not supposed to the page number
23.
Yes.
Statement of the LW 1213.
Page number 23.
23. Statement of LW 1213.
23.
It mentioned the copies are not there.
1 minute. Yes.
LW 1213.
Yes.
Circular witness speak that the around the LWC and accused criminal liquor and high life during company to be skills. The accused love the car in dash and engine and early day home and went to his house in the provincial commission.
According to you, she was present in the car. See, this LW3 is present in the car. LW13. No. What it says is in the memo of evidence, page 23, circumstantial witness, she speaks that she, along with LW13 and accused, consumed liquor in the Prost View pub and High Life Living Company, Jubilees, and the accused drove the car in rash and negligent manner up to her home and went to his house in intoxication condition by driving his Ford Figo car. Yes, what do you say about this finding?
13 he dropped that home. It seems she said, don't go now, you are drunk. No, he said, I'm glad to go. But anyway, he went alone, he was alone.
But from the evidence of LW 12 and 13, it discloses that your client is an intoxication.
Now, your lordships are seeing evidence and driving cases. There is a limit, as you rightly pointed out, lordships have pointed out, that is there a limit which is measured? Have they taken the blood sample? Nothing much. As far as drunk driving is concerned, it is if there is no prima facie case. Only point is, my only submission is that why not the road India and 304 part 2, why not there are 15 number of cases for a drunk driving that has caused. One my learned friend is trying to interest about something. What is the referring to the BMW case where what is happening? The driver hit one person. Supreme Court said he should have applied brake even before hitting the other person. Because if he didn't take the caution and hit the other 5 persons continuously, therefore they are liable for culpable homicide. Not in this case, then every 304 case will be converted into 304 part 2. That is so. Page number 13. I'm not coming to
page number.
What is concerned?
Yes.
Page number 13. Last paragraph.
Yes.
The immediate person in that in so day during the daytime, which persons who are extremely bothered in electrical work to work, contract person in terms of into the house in evening. Later on, the above data will go to the house and put people problem or something informing the matter and all in the classmates who was also person. So also asking him to for which she asking him to pick up the nearby lifestyle building according to happy for 9 PM went to the lifestyle building. They can fit. pick up head of staying away. They both Jupiter's criminal Kumar Gauri and want their common subsequent who is joined with them in the state club, then the accusing Prashant Kumar along with Subir Gauri and Kumar Pachi have consumed liquor and enjoyed their till midnight by participating in the dancing and much for his years they will not for his investigation further revealed that from the mail accused along with the above Kumar Gauri and Sonju like attending the trains for 2 days Hyderabad, wherein they are enjoyed their till 2 a.m. and dancing in the they are accused cleared bill so somewhat probably by his ICICI credit card. Bill one of his friend. So he paid the remaining bill.
Is there any stay in this case? Is there any case stay in this case?
Not in this case.
Criminal petition.
The other case we have the concepts for repetition
That is with regard to appointment of parties.
before the session. In this case, there was a mistake. Notice was ordered. Absolutely. In fact, I have given some letters to the registry. We posted so that I will have the matter. The lordships are available by the post. Road of all. In Sanjeevananda's case, we got there 2 cases. Shaila's case and Sanjeevananda's case, multiple killings in the land of the area versus state of Maharashtra. Shaila's case, that is where again so many people died. Those are exceptions. Number 41, actually. Number 40.
Yes.
Knowledge of the dangerous and factors are likely to benefit on the act. We will get some trained for the category of purpose instead. Not doing the act, match and engage in learning them aware of the risk and that particularly.
I will fix the date of hearing for this criminal petition. It requires some concentration rather than hearing in partly. Post this to both petition and
2 cases only were Supreme Court cases.
No, you file a synopsis.
304 A.
I am aware, Mr. Nash. You file a synopsis, file a small synopsis is so as it is convenient for me to, while even writing for the judgments also. Yes, when do you want?
In time after Diwali, 2 weeks.
Yes.
Even stay may be extended.
Yes. Stay granted earlier is extended. At least these 2 cases. A hearing on 7/12/2020. It's a court pleader, it is required to be decided so far as the second case is concerned, whether it is 304A or Part B. Once it is decided whether the additional special public prosecutor is required to be appointed or it is go, the tolerance of the court is in 304B, Part B, it is a sessions. 304A, it is a magistrate. Right of remedy is a constitutional right to the citizen. By virtue of altering the provision, he will be benefited to go before a concerned magistrate court. And thereafter, he is having another remedy of filing an appeal before the sessions. Thereafter, he is entitled to file an appeal before this court. And rather, if we straight away invoke the provisions of the sessions, he will lose his right of contesting the matter. Therefore, to the extent of that point is concerned, you forget about the merits and demerits. That is always an issue to be decided. That we will examine everything. No, I am on the. There is a circumstantial evidence according to you. You have already examined LW12 and LW13. Then piece of the car. There are some, all the evidences which you have collected for the purpose of investigation to add section 304B is circumstantial evidence. There, according to him, there was no direct evidence at all. It is an evidence being collected for the purpose of adding section 304B. He is himself admitting that 304A is concerned, he is ready to face the trial. And he also says that by virtue of 304, it is a magistrate trial.
Therefore, he is losing his right to, therefore court should be very careful because it amounts to taking away the right being given by the constitution.
What if there is patient evidence?
We will examine. It is almost all hearing criminal appeal rather than the cost proceedings. Yes. Extended. Yes.
Step number 50, Mr. Venkateshwar.
Yes, Mr. Venkateshwar Reddy. Yes, what is your case? Yes, what do you say? You filed a final report.
Yes.
Where is that report? Give a copy to the other side. Final report stating what? It is civil in nature. Yes, Mr. AGP. Stating what? Yes, your relief is only not conducting investigation. They have conducted and filed a final report. Run. It's a repetition is filed. Petitioner is the complainant. Mr. Yes, what do you say, Mr. Government?
అదే తలకాయ అది ఏంటంటే వేరే వేరే వాళ్ళ పేర్లు ఇస్తున్నాము యాక్సెప్ట్ చేస్తలేరు
చేయొద్దని చెప్పి ఉందా?
చేయొద్దని
కోర్టు ఆర్డర్ ఉందా? తీసుకో మరి కోర్టు ఆర్డర్.
ఇంకా వేరే వాళ్ళ పేర్లు చేస్తుంది ఆమెకు మెసేజ్ వస్తుంది ఆమెకు మెసేజ్ రాదు కదా అది.
This case on 21/12/2023.
Item number 52.
My lords.
Yes.
Let I appear for the petitioner in this matter, my lords. Counter affidavit has been filed by the respondent number 4, my lords. Just to refresh the memory of this honorable court, my lords, this is a writ petition filed being aggrieved by the inaction of the police in not registering an FIR based on the complaints submitted by the petitioner. Complaints were, my lords, with regards to derogatory, defamatory messages that were being circulated on WhatsApp and other social media platforms. That has been categorically pleaded in my affidavit, my lords. On the last occasion, the learned GP has stated that the complaint was not received through proper channel, but in the counter affidavit, my lords, they have stated that the complaint has in fact been received through proper channel, but apparently the dispute pertains to civil in nature. Therefore, they have conducted an inquiry, and because it is civil in nature, they have closed the case. Well, initially they stated they did not receive the complaint through proper channel. Now in the affidavit, they state that it is through proper channel. Subsequently, my lords, they state that an inquiry has been conducted, and because it is civil in nature, it is closed. My respectful submission is that, my lords,
You file a protest petition under section 202 CRPC. Questioning the same. Since they have already inquired into complaint and file a counter affidavit stating that the complaint has been closed as civil in nature.
But the fact of the matter is that, my lords, all the messages that are being circulated online, for which I am also ready and willing to produce a CD and other electronic things also, they have not entertained that.
No, I am not saying that you don't have any case, but I am only saying that you are having a remedy before the competent criminal court by filing a protest petition under section 202 CRPC.
Yes, my lord, that is very well available to me.
Yes, Randy, this petition has been filed. Questioning the action of the respondents. Not registering the complaint of the petitioner dated 4/5/2023 and 18/8/2023 as illegal, arbitrary, unconstitutional, and contrary to the section 154(3) CRPC. And consequently prayed this court to direct the respondents to act upon the complaints submitted by the petitioner dated 4/5/2023 and 18/8/2023 in registration of the cases. Mr. The grievance of the petitioner in this petition is the sixth respondent wantonly and deliberately defaming the petitioner in the right thinking persons of the society in electronic media, and that the petitioner has causing damages to the work institutions without any basis and proof. Lister. And the sixth respondent also spread a propaganda circulating videos of derogatory statements against the petitioner with a malified intention to margin the status of the petitioner by WhatsApp messages. Mr. Having come to know the petition about the action of the sixth respondent, deliberate actions of the sixth respondent, he has filed a complaint on the file of the respondents dated 4/5/2023 and 18/8/2023, requesting them to take appropriate action in accordance with law. Mr. Counter affidavit has been filed by the respondents, wherein it is stated a complaint submitted by the petitioner dated 4/5/2023 and 18/8/2023 was received by the respondents, and during the course of inquiry, petitioner has lodged another complaint dated 1/9/2023, stating that sixth respondent is causing. Sixth respondent is using WhatsApps, using derogatory, publishing, circulating derogatory and abusive statements in WhatsApps. Thereafter, the complaint received by the petitioner was transferred for point of jurisdiction to the police station Langaros, and the jurisdiction to the
This is the police station.
For want of jurisdiction, the complaint submitted by the petitioner transferred to the station house officer Langaros by letter dated 29/8/2023, and after conducting investigation by the said police, the investigation revealed that there are civil disputes between the petitioner and sixth respondent. As such, complaint of the petitioner has been closed as civil in nature. The learned counsel appearing for the petitioner has submitted that the respondents have not furnished the closure report to enable the petitioner to avail the remedies as available in law. Which respondent? The fourth respondent is directed. Fourth respondent is directed to serve the copy of the closure report to enable the petitioner to avail the remedies as available in law. You serve the copy of the closure report to the petitioner.
Yeah.
Yes, with above observation, the petition is disposed of.
Public.
Yes.
May please, Your Lordship.
Yes.
Lordship, this present matter is filed for declaring the action of the respondent in defreezing the petitioner's account, my Lordship, without proper action, my Lordship.
Any counter affidavit has been filed?
Yes, my Lordship. They have filed, my Lordship.
Stating what?
My Lordship, they have given a notice to the respondent, my Lordship. My Lordship, I invite to see page number 11, my Lordship. 19/5/2023, the notice have issued to the bank and defreeze the account, my Lordship.
What is stated in the counter affidavit? I am asking.
Lordship.
It's submitted that the respondent number 2 filed application before the Honorable Petitioner TSHC, informing about the debit fees of the account petitioner and 91.
Is the name of the petitioner is mentioned in the complaint first information report or the charge sheet?
First information report. Should not charge it not filed.
The first information report you have been shown as an accused.
Yes, my Lordship.
Then they are entitled to seize your account.
Lordship, actually, I have filed a release to release the to defreeze the account, my Lordship, before the trial court, my Lordship.
Then you are entitled to
my Lordship, on page number 14, my Lordship.
You are entitled to pursue the relief by application.
I have filed, my Lordship. I have filed, my Lordship, that the copy is closed with the page number 13.
Why you filed a writ petition here, having filed a petition?
My Lordship, the Honorable Court have objected the thing. On page number 14, my Lordship, kindly see the page number 14, my Lordship. Returned as per the crime records, the account not freezed.
Yes, what do you say? Page number 14.
Page number 14, my Lordship.
Application filed by the petitioner was returned dated 31 July 2023, stating that as per the criminal record, the account not freezed. What do you mean? What do you mean to say that? Say it is recorded by the learned magistrate, and you want to see the counter affidavit filed by Sub Inspector of Police. What informed? See, you have not produced, not stated before the concerned court that this account number so and so of the petitioner is a crime property, and you have obtained the permission from the magistrate under section 102 CRPC. You have to intimate immediately. You are saying that you are followed. If you followed 102, where is the question of magistrate being recording a docket proceeding saying that it is not a crime property? You get the clarification from your concerned officer about the endorsement being made on page number 14. Huh? You call your officer and get the clarification over the endorsement being made by the concerned magistrate. Yes, if you have shown it as a crime property, then I will direct the petitioner to avail the remedies as available under section 451 read with 457 CRPC. Yes.
To be posted for next week, my Lordship.
Yes, this case on 16 level.
Deeply obliged.
Item number 54, Mr.
Yes, argue main case. IA2 filed seeking implead. IA2 filed for seeking impediment of proposed respondent as party respondent to the petition is allowed. Yes, argue the case. Argue main case. I allowed your IA. Why you are arguing SIA if your colleague will argue the main case? Why tomorrow? As if you are prepared to argue the matter, see, your IAI allowed, argue the main case. Case IA2 of so and so, filed seeking implement as a party respondent for the proposed respond number. Proposed respond number 11. Yes.
Number 55, Mr. Rajan.
Yes.
Krishna is the woman, the taken forcefully to the police station. And it is in the admitted that.
Yes, have you filed your counter affidavit, Mr. Yes. Yes, what is your case?
Page number 9 of the counter.
Page number? Page number?
9 of the counter.
Yes.
Page number 9, that is the FIR.
Yes.
Where the date of registration of the FIR is 17th August 2023.
Yes.
And GD entry is at 17th August 2023. One o'clock.
Yes.
9.
Yes.
They have taken this division other 3 women. On 16th you are asking. They have filed the written statement on 11th we received the complaint. But whereas in FIR.
That is your allegation.
No, they have stated.
Where they have stated in their counter.
The written statement on 11th and in the counter page number 3 you are asking. Page number 3.
Yes.
On 11th, 8/2023 stating that he is working as a security guard.
It is a complaint. It is a complaint being lodged by the contesting agents.
There is no fight in the GD entry. The application is true to lodging. Whatever they applied in GD entry, they have stated that on 11. It is not there. They have created a story. On 16th, 9th, 8th.
Yes. What prevented you when you have received a complaint on 11/8/2023? Why you waited for registration of the crime till 17/8/2023?
And Bolivia also not agree that at 8:30 you saw any woman and they say that because she doesn't have transport facility, on the request we have taken her. So why you forget to drop her? They you are taking to the police station for information. Because such a gentleman definitely want to drop her again. Nothing is there. Simply without you have the video CDs in place, everything. Let them file for this court. The person that usually going to conduct to come out.
Your allegations mentioned are the contentions raised in the counter affidavit is not the gospel truth to rely upon by the court. See, when you have received a complaint on 11/8/2023, what prevented you to wait for the without making GD entry till 17/8/2023? What section 172 CRPC says it ends, sir? 172.
Then they can file video recordings of the police station also to satisfy.
You read the 172 first. Yes, what it says.
The police officer making an investigation shall day by day duties in investigation of the diary, setting the most of time information, sharing the time which investigation and based on step by statement of the circumstances.
You produce general diary and other original records related to this case by the next date of hearing. The Learned Ground Federation is directed to produce the record relating to the general diary and record relating to the crime number. That we will go a little later. Records relating to crime number 645 of 2023, including general diary. Yes. including general and TCM, record and అది కూడా వస్తుంది. Yes. List this case on 7/12. No. Elections are there, all police officers are busy with the elections and counting. You are aware. What should take into consideration of so many things? See, there are elections, all the police officers.
There was a serious, this honorable was very complicated. That the dignity of the women are playing still. It will be like a case. After that, this incident happened.
I mean, look, see, I have straight away put a question. In fact, you have not raised. I said section 172 of CRPC specifically says that general diary has to be maintained by day and with specific timing. Therefore, I put a question to him when I complain. We will examine all. అన్ని ఒకటే రోజు కావాలంటే ఎట్లా బిర్యానీ అయింది అన్ని కలిపి కూడా నీకు ముక్కలు బిక్కలేదు తన్నం తింటున్నావు కొద్దిగా వెయిట్ చేయాలి. ఎస్ not necessary. What is the case? Who is appearing for the petitioner? You are for the fourth respondent. Who is appearing? FIR is already registered. Yes, right. This petition has been filed to declare the action of the respondents not registering the complaint dated 25/7/2022. Yes, what do you say? Yes, madam. Yes, survey copy, understand. This writ petition is filed. Questioning the action of the respondents, not acting on the copy submitted to the petitioner. As illegal, arbitrary, and consequently failed this court to direct the respondent to take appropriate action as per the section, take appropriate action as per section 154(3) of CRPC and for other reliefs. Petitioner claims to be owner and possessor of house bearing number 15-10-8, situated at Rastogi Nagar, Illandu Road, Khammam district. This further case of the petitioner, said property also mediated in the Gram Panchayat record, and the petitioner is regularly paying the property tax and other taxes to the local authorities. The grievance of the petitioner is that even after the legal debt, what is your grievance when there is seventh respondent is interfering with his peaceful possession and causing inconvenience for enjoyment of the said property? He has lodged a complaint with the respondent police, but the respondent police, even after receipt of the same respondent on the file of the